they let it disband, and that's why Jackson lives on the show.
Good morning, everyone. I'm Dr. David McClendon, President of the Board, and I'll call this meeting to order for May 18th, 2023, the full board meeting of the Mississippi State Board of Medical Licensure. Let's stand. Dr. Gene Loper will lead us in our invocation.
Dear Heavenly Father, thank you for this opportunity today. Thank you for this opportunity to meet today. We have special blessings all in attendance, and our meeting will be both edifying and glorifying to you. Our decision will be both fair and show your mercy and your glory. We ask all these things in Jesus' name. Amen. Amen.
Dr. Kennard will lead us in the pledge.
Just stand at attention to the flag, please. Pledge allegiance
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Moving on to announcements and public comments, I'd like to recognize our special guests of the meeting. Our Ms. Julie Brown is our court reporter. Thank you for serving today. And our Special Assistant Attorney General, Ms. Alexis Morris. Thank you for your help today. Any other public comments? Moving on to item number 4, the Executive Director report. Dr. Cleveland.
Thank you, Mr. President. So today will be a fairly brief report. In licensure, March and April, we had 118 PPO license issued, 1 podiatrist, 9 PAs. Compact licensures was we had licensed an additional 112 licensees and gave out 14 letters of qualifications for the IMLC. For other states, we certified 498 licensees. That doesn't exist anymore. That's why what was supposed to be removed. I apologize. Just so everybody knows, the legislature said that we can't require them to register with us anymore. In March and April, the investigations department received 76 complaints. We closed 35 cases. We opened 36 new cases for a total of 68. And then cases closed within 7 days was 96%. PMP reports 125, resulted in further action was 80. And then I just wanted to mention this for committee chairs and starting after the July meeting is I would like the new committee chairs to consider having a time between each board meeting that is a committee meeting or is at least scheduled, whether it's canceled or not, for a very specific time. So we'll use rules and regs as an example. It'd be every first Monday of the even month at 4 p.m. You know, that's just kind of making that up. But so I really want to try to encourage our committees to do more. I guess that's where I'm getting at. So with that, I'll be glad to answer any questions.
Thank you, Ken. Any questions of the board members for our director, our executive director? Moving on to item number 5. We go to tab 5, approval of the minutes of the executive committee for March 22nd. We could review. Or any edits needed?
I move we approve the minutes as written.
Dr. Joyner has a motion. Is there a second?
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Any abstentions? Motion carries. The minutes are approved. Moving on to item number 6, approval of the minutes of the board meeting dated March 22nd, 2023, tab 6. Any needed edits or discussion? I'll entertain a motion for approval. Is there a second?
Second.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Any abstentions? Motion carries. Moving on to item number 7. The report from the executive committee meeting from May 17th, yesterday. Dr. Lippincott?
We had a Zoom appearance with Dr. Risk. And he was requesting an exception to the rule to take the specs for a license. And we recommended that he take the specs prior to his application. We had a personal appearance by Dr. Khalid, who was lacking some documents in his initial application, and he provided those documents, and we approved his application for licensure. And we had a Zoom appearance by Dr. Robert Glenn, who was requesting an exception to the rules for 20 hours in-state practice and 75-mile rule to provide remote supervision for nurse practitioners who were providing telepsychiatry services in urgent care clinics. And we denied his request for an exception. And that's all I have to report.
Any questions from the board about the executive committee report? I'll entertain a motion for approval.
Moved.
Is there a second? Any further discussion?
Second.
All in favor, say aye.
Aye.
Any opposed? Any abstentions? Motion carries. Moving on, item number 8, reports from committees. Scope of practice, Dr. Kennard, is there a report?
No report.
Dr. Lippincott, is there a report from the professional health program?
The PHP had their every 6 monthly board of directors meeting last week, and there was a good report that they in last year in 22 they had 149 total participants in the PHP, and the majority of those were physicians, and we were encouraged that we had 4 self-referrals last year. Is that correct? Yeah, 4 self-referrals, which is good. And they've had prescribers summits, which were very successful, and the annual Caduceus retreat for participants is the 1st of next month. So that's all.
Thank you. Dr. Gibbons, are you with us on Zoom?
He sent a text. I have no report.
Okay. Well, per Dr. Gibbons, there's no report for the telemedicine interstate license or compact committee. Moving on to licensees, education and communication. Dr. Owens, is she with us on Zoom?
She is not.
She's not. Dr. Gersh or any other committee members are aware of activity on this committee?
I'm on the committee and I cannot report any activity.
Also moving on, the physician advisory, assistant advisory task force. Again, Dr. Owens is not present. This is usually just an ongoing work group of reviewing these physician assistant protocols. Jonathan, any updates or changes
No, sir.
related to this?
Dr. McClendon, I would like to make the board aware that FSMB and the National PA Association have approved the language for a PA compact.
Great.
So it's portability. So if you're licensed in one state, you're licensed in any state that's a member of the compact. You don't have to be licensed in each individual state. We actually, at the IMLC, drafted some language that required you to be licensed in every state, but that was not successfully passed out of the IMLC Executive Committee. So the only language that exists right now is PA portability. It actually passed in Utah. It was introduced in 4 other states, but has not passed in any other states yet. So,
Thank you for the update. Moving on to item number 6, rules, regs, and legislative. Dr. Joyner, I think you may have something for us.
Yes, we have a report. The first is concerning the practice of physician assistants. You have this information that has been provided to you prior to this meeting, so hopefully you've read through it. There are some changes. Basically, it starts out the scope. The physician assistant scope is the same as the MD scope, and the physician assistant is considered an extension of the MD. The second section is definitions. There's no change there. The third section, Rule 1.3, qualification for licensure. This is basically unchanged. And if you have any questions as we go along, just let me know. The Rule 1.4 concerns temporary licensure. This is again unchanged. We can grant a temporary license under certain conditions for 180 days. It can only be extended one time. Those conditions are spelled out in that section. The requirement for a protocol, Rule 1.5, you will notice that in the first line, physician assistant shall practice according to a board approved is struck. Protocol, which has been mutually agreed upon by the physician assistant and the supervising physician. Basically, what this means is that the physician assistant and the supervising physician must have a protocol. They must have it written and documented, but they don't have to submit it to the board. That has to be available if our board investigators or for some reason we come to their practice and want to see their protocol. They do have to report through the MELS system that they have such a protocol. The next section is prescribing controlled substance and medication by physician assistants. This basically mirrors the MD requirements of that same section, and there's essentially no change. Is there any questions concerning that? All right, next year we'll go to Rule 1.6, which is struck supervision. And it's revised in 1.6. It says supervision means overseeing all activities and accepting responsibility. I think the key word there is accepting responsibility for all medical services rendered by the physician assistant. This is basically the same language that we have now, but you will go down to the underlined section. Before any physician assistant shall practice in a location greater than 75 miles. If they're going to practice greater than 75 miles from the supervising physician, then they are going to have to pony up a protocol to the board so that the board can look at it and evaluate it and approve it. Any questions concerning 1.6? If not, we will move to 1.7 termination. The physician assistant shall notify the board in writing immediately upon the physician's termination. The 1.8, they are required to notify us of any address change, I think within 30 days. 1.9, continuing education, essentially unchanged. They're required to have 100 hours over a 2-year period. 50 of those hours have to be category 1 CME. Rule 1.10, I believe that is. Let's look out the one. Okay. Identification, this is unchanged. Supervising physician has to make sure that there's no other PAs operating under his licensure and that this is available to the public. Physician's liability is unchanged. They have to provide evidence that they have liability insurance. Renewal schedule is unchanged. It essentially mirrors the MD renewal schedule that we go through every year, and having to renew our licenses by June the 30th. And I remind you right now, everybody around this board, up your license by June 30th. Rule 1.43 deals with disciplinary proceedings, which basically outlines how things come before the board and how they're handled at the board. Rule 14, impaired physician assistant. Again, this is has some strikes in it, but it is made to mirror the MD's requirement for disabled physicians. Then 1.6 is effective data rules, which will be filled in after all this goes to OLRC and gets approved. So I want to stop here unless, are there any questions concerning physician assistant rule changes? If not, I would like to call for a motion to approve if necessary.
Can we do them together?
We can, but I wanted to get this out of the way, but we can do it together. But for your sake, we will do it separately.
I submit that motion.
You made a motion. Do I have a second? Second. All in favor, say aye.
Aye.
Any opposed? The ayes have it. After this, it will be submitted to the OLRC, right? They will look at it or either approve it or suggest changes. They will send it back to us, like we're fixing to do another section after this. And we will, if approved, we will have the final adoption. All right, the next concerns cannabis certification. And basically, we're very constrained on what we could write here because we basically have to write exactly what the legislature has told us that our parameters are. So if you think it needs to be done another way, you don't have an argument with us, you got an argument with the legislature. And basically, as it starts out the scope, all licensees are required to register as certifying physician with the Mississippi State Department of Health. No licensee is required to register with the Mississippi State Board of Medical Licensure. Now, this does prevent redundancy and a doubling of work effort, but we know where that registration is, and we know their telephone number, and we know how to get to it. So, any questions concerning that? All right, under definitions, a bona fide practitioner-patient relationship means that this physician or certifying physician has a bona fide relationship with a patient, not just hello, how are you, but they are a patient. They have been evaluated by that physician. They have arrived at a diagnosis or treatment plan, and it is documented in their medical records. Anybody have any questions about a bona fide physician? Physician-patient relationship. The practitioner has to be available for follow-up care, which is what the duty that we're all held to anyway. It goes into the definition of a practitioner means a physician or physician assistant who is licensed to prescribe medicine under licensing requirement of the boards and the laws of this state. In relation to a non-resident card holder, the term means a physician or physician assistant who is licensed to prescribe medicine under the licensing requirement of the respective occupational boards and laws of the state or territory. I think what that means is if you have somebody from Alabama that wants a certificate to go to the Department of Health to get permission to have medical marijuana, and they're approved by somebody from Alabama, they need to have a Mississippi license, but they're under the auspices of the Alabama Board of Licensure and the laws of that state. Any questions concerning that?
Explain that one more time, Tom.
Okay. If you're a Mississippi physician, you're a certifying physician, and your patient is from Mississippi, then you have the normal requirements that you have to be certified by the Board of Health. And they get their certificate and go to the Board of Health, and they give them, and it's described further on in here, the certificate that they can go get medical marijuana. Now, there are physicians outside of Mississippi that may have a Mississippi license, but they're under the auspices of, and I used Alabama, so we'll still use Alabama. They're under the Board of Licensure of Alabama. They're under the laws of the state of Alabama. They need to have a Mississippi license to prescribe. But they've got to have license where they are located.
Right.
Okay. So if they prescribe to a resident of Alabama, resident of Mississippi, then they have to do the requirements of the board of the state health department.
So one of the requirements of the application is that the patient has to have evidence of Mississippi residency.
Well, I think you're talking about a situation, and you may want to address this, where a resident in Alabama has medical marijuana. He's walking around in Mississippi. He needs to make sure that he has been prescribed by a
Mississippi physician.
that doctor's going to have a Mississippi license,
Right.
but he may not be in Mississippi.
I think the point of clarification is this, it's under the law, you can have two 14-day supplies. If you're a medical patient in Alabama, but you haven't been certified in Mississippi, Mississippi allows you to have a temporary card for a 2-week supply 2 different times. So a 30-day supply in a year from another state. So if you're visiting Alabama and you're a medical marijuana patient in Alabama and you visit Mississippi, you can apply to the Department of Health for a temporary certification in Mississippi. I think the deal is that the physician in Alabama, in order for that patient to get that temporary certification, that Alabama physician also has to have a Mississippi medical license.
Yes,
That's the clarification. I wasn't aware of that nuance.
that's the way I read it.
May need to kind of get that clarified through the law to make sure it doesn't conflict, but I think the temporary part of it is speaking to the patient's temporary certification to get cannabis in Mississippi from another state. That's in the law. Now, I wasn't aware that the Alabama physician would also have to have a that certified the patient in Alabama also had to have a Mississippi license for them to get a product in Mississippi temporarily.
The
We
way I read
need to
it,
confirm that.
yes. The way I read it is any physician certifying in Mississippi has to have a Mississippi license.
True.
They can live in Alabama.
Okay,
They can do all of their practice in Alabama,
okay,
but before they can practice on a Mississippi patient, they gotta have a Mississippi license,
right,
which
okay,
is the way we do everything else.
right. So we're talking about kind of two different things then. Yeah.
Two different situations.
Yeah.
I got a question. If somebody's certified for medical marijuana in Alabama and they come to Mississippi, will they get in trouble for not having a Mississippi card?
They can get a temporary one
But
as a
they got-
non-resident.
Do they have to see a physician to get a
No,
temporary
they
card?
apply to the Department of Health for that.
Okay,
They do not have to be certified in Mississippi. They get two weeks plus. And that's it
So-
for that year.
And that's not in our rules and regs,
No.
temporary.
That have anything to do.
No.
Yeah.
No,
is that in the, that's a statute?
it never did, and it especially doesn't now.
So, first of all, that situation doesn't involve this board.
Right,
To collect, if there's a marijuana patient in Alabama, they are not allowed to bring their Alabama marijuana into Mississippi. It is still federally illegal to transport marijuana across state lines. So if they were going to come spend any significant amount of time in Mississippi and they still wanted to be a marijuana patient, they would have to apply for this temporary card. That really has nothing to do with us. And we kind of lose.
Yes.
Yeah.
Why do we have that in our rule?
We don't. That's not what this says.
Oh, it looks like it.
Dr. Kennard, I think it's exactly right, Dr. Cleveland. This is for patients who certified marijuana patients in their home state.
Yep.
They've been this rule says they have to be properly certified in their home states. If they are, they come to Mississippi temporarily, Department of Health releases them a temporary card, allowing them to get marijuana at Mississippi dispensaries, but only for the two occasions. Again, that's more a matter of the patient. An Alabama physician who is properly certified, prescribed medical marijuana in Alabama, we're just using that as an example, can prescribe for their patient. Dr. Cleveland said, the minute they carry Alabama medical marijuana in the state of Mississippi, they're violating federal law. If they leave their supply at home, come here, our Department of Health will give them that temporary.
So it really has more to do with Department of Health.
yes,
It's a same type registrations in Mississippi, I think there are different questions. Is that correct?
that's right.
All right, and then the next thing it goes into is chronic pain and describe what chronic pain conditions are. It goes into debilitating medical conditions such as cancer, Parkinson's disease, spastic quadriplegia and such. Goes into chronic terminal debilitating disease, and any other serious medical condition that is treatment added by the Mississippi Department of Health. Medical use. It describes the medical use all the way from the growing to the processing to the dispensing and to the use. And it's just making the distinction between non-medical use, like you going out back and planting a plant. That's still not legal, not going to be legal. It's got to be medical marijuana. Scope of practice means the defined parameters of various duties, services, activities that may be provided or performed by a physician as authorized under section 732533 or by a physician assistant and the rules and regulations adopted by the board for those practitioners. Then it goes to define what a written certification is. Again, it's striking out certifying practitioner and it defines what a written certification is. Treatment plan is struck. Treatment plan is something we all do and they're all bound to. And under certification, it says no person shall be authorized to use medical cannabis in this state unless the person has been diagnosed by a practitioner with whom the person has a back to that word bona fide practitioner patient relationship within his or her scope of practice. Has a debilitating condition for which practitioner believes his or her opinion, person will most likely receive medical or palliative care. And he has received written certification of that diagnosis from the practitioner and has been issued a registry identification card that comes from the Mississippi State Department of Health. So that basically defines the patient and the parameters the patient has to meet. It also describes what a written certification is and the requirements of that written certification. It also states a practitioner, after a practitioner has issued a written certification to a qualified patient, he may assist the patient in registering for a registry identification card with the health department. After he receives a written certification, he is required to see that patient again in 6 months to see how the patient's doing, whether the patient continues to need medical marijuana or any other follow-up visits. It then goes on to pediatric certification. Basically, anybody under the age of 18 has to have their parent, custodial parent or guardian available. The practitioner has to inform the parent or guardian of the benefits, the risks, and the side effects and the dangers of medical marijuana so that everyone in the loop understands what is going on. For those young adults that are between 18 and 25, you're required to have evaluation by 2 certifying physicians. Both have to agree that you are in need of this medical marijuana. It also goes on to describe what to do if the patient can't get to one of the certifying physicians. In that case, if that's the situation, then only one is required, but it's got to be documented. Next is CME requirements, and basically the CME is what's set out by the Mississippi Department of Health. They shall be required to complete a minimum of 8 hours of CME and medical cannabis in order to issue written certifications. And after the first year, they're required to complete 5 hours continuing medical education annually. And then it says practitioners shall not be required to have any additional qualifications to be authorized to certify a qualified patient for a registered program. A practitioner shall not be required to register to certify patients with any state agency or board other than the Mississippi Department of Health. Rule 1.6, advertising is struck. I imagine because that's going to be hard to enforce, pretty much impossible. And then any violation of the rules or any provisions of the Medical Cannabis Act constitutes unprofessional conduct in violation of the Mississippi Code, may be subject a licensee to discipline. Any further questions?
We're completely striking the concomitant controlled substances and cannabis certification.
Yes.
Yeah.
That was put in the statute.
So that topic will not be addressed at all in language.
Doesn't need to be because we're not regulating the cannabis. Just opioids and all that still have to do with drug screening.
Right.
The only thing, to my knowledge, just to make everything Tom just had to go through, make a little bit more sense, is the only thing that's struck that we had in there that we added uniquely to this whole mix outside of the legislation, and correct me if I'm wrong, was about the drug screen. I mean, that's the only thing that we actually implemented above and beyond what
registration.
the law and the registration, yeah.
Yeah.
So the legislature, one of the revisions they made in their original act in this last legislative session that is most meaningful to clinicians is the requirement that the board implemented and carried over from opioid therapy for a urine drug screen before you certify. Their language is that you're still free to do a urine drug screen as you wish, but you cannot deny a patient a certification for cannabis based on the results of a urine drug screen. So they basically are not going to allow a clinician to use a drug screen to make a better decision for certification. of a patient.
What about the opiates and
No,
benzodiazepines?
that's still our purview and you're still required to do that, but not for cannabis.
So if they get cannabis or doctors not supposed, if they have a drug screen positive for cannabis, is there a proscription against prescribing benzos or opiates?
What we as a board may need to address is THC in a drug screen for an opioid patient. With a card, that's for later, but I mean, that's something that,
But there's currently no proscription for that. Okay.
And if I may, while we're talking about urine drug screens.
Yeah.
If we go back to 2018, when we first revised 2640, the message from this board has always been that the urine drug screen should be a conversation starter, not a reason to either not prescribe or to fire the patient. It's a conversation starter, and then based on the conversation, you make additional medical decisions.
Yeah.
But the urine drug screen results in and of themselves
But
So that
we do have a very strong warning about prescribing benzodiazepines and opiates together.
we do,
But there's still a little wiggle room there.
there is.
there is.
For
But specifically
Individual
talking about
cases.
urine drug screens, we have been very consistent over the past 5.5 years in our message that it's a conversation starter.
Yeah, so in support of that, in support of us in that interpretation of the rules that we have, in 2016, the CDC actually silently somewhat and non-publicly issued a policy statement recommending against clinicians that participate in chronic opioid therapy for their patients for chronic pain management. They recommended against testing for THC in their drug panel. That's from the CDC. That you can look it up, Google it right now. The reasoning behind that is if you dismiss a patient simply based on that, in the context of someone behaving, showing up their appointments and otherwise being compliant, just for using THC, you are now putting them in a lurch that they are never going to get into another pain clinic to have their pain treated with an opioid or not. It just will not happen. If you get dismissed from one pain clinic, it's very, very difficult to get into another one. And they are probably then very vulnerable to going to the street to get something for their pain. And so now we have a medical cannabis law that somewhat protects them by a physician or a clinician certifying them for the cannabis. So I think the only thing that we could do is go back and look at the THC and single it out, and whether or not some language needs to be changed about THC for opioids. But
So medical marijuana is illegal as far as the feds are concerned,
that's correct.
but the feds are issuing the directive on what to do.
Yeah, they're talking out of both sides.
I don't know. Two different agencies. Yeah.
There's two different agencies, but
So
they're
the DEA and the CDC are back and forth and very
The
confused.
changes that Dr. Joyner has gone through are consistent with the current statute that was passed this last legislative session.
Yeah.
what if
Refocus back on that.
what if they test positive for THC and they're not certified for medical THC?
Well, yeah, that's correct. That's why it comes into play.
So.
Like, should you do anything about that or not, or what?
So the CDC recommends not even testing for THC.
That's right.
But it's on all the drug screens.
Yes. Sure, they don't,
We discussed that in committee, because I think we should need more discussion, because maybe not this, but.
Yeah.
To bring that back, that is
Yeah.
that is already coming up. I promise you, that's already coming up.
Yeah.
All right, any further questions concerning medical cannabis? Not, I will entertain a motion to approve. We have a motion, do we have a second?
second,
All in favor, say aye.
Aye.
Any opposed? It does carry. Thank you. So this will be taken to the OLRC. All right. Now, we've had return from the OLRC changes that we approved, I think, at our last meeting. These changes concern the practice of physician, the licensure requirements for the practice of allopathic doctors and osteopathic doctors. Licensure requirement for the practice of podiatrists, temporary licensure, license rule governing the practice of allopathic physicians, osteopathic physicians, podiatrists, physicists, radiological assistants, and acupuncturists. The effective application. And the last one, the use of diet medication that was sent to the OLRC. The OLRC approved these, they're returning to us, and we must approve them for the final step. Does anybody have any questions concerning these that we have already approved?
Did the OLRC make any recommended changes?
No changes.
No changes.
Motion to approve?
We have a motion to approve. Do we have a second?
second,
We have a second. All in favor, say aye.
Aye.
Any opposed? The motion carries. I want to thank everybody on my committee for the time they put into this. We will meet again in a couple of weeks, as Dr. Cleveland was saying. And we'll go from there. Thank you all.
Dr. Joyner, thank you for your work. This is the committee that requires the most thought and work and time, and I appreciate your commitment to it. Moving on to item number 9, the Ville Dasaboy MD UMC nephrology dispensing investigational medication. Is Dr. Dasaboy here? Dr. Dasaboy, good morning.
Good morning, how are you all?
Great.
I did not really expect to come give a speech here, but. All right. So I'm appearing before the board because at UMMC we do a lot of research. And traditionally we use a research pharmacy, which UMC has, which is well and good and actually saves us a lot of problems. However, our main operations are based at the Jackson Medical Mall, whereas the research pharmacy is really based out of the main campus. And so from time to time, where they have a problem coming over to where we are located. And so we were asking that in the few instances where this may be a problem, our division may be allowed to do the needful. Now, this would just be regular drugs. These are not controlled substances. It would be, investigational new agents like the new ACE inhibitor or the new SGLT2 inhibitor. So we would do all that is necessary to maintain the proper logs of the supply of the investigational agent. And we do essentially everything that a research pharmacy would be doing. We already have the facilities. We have the locked room. We have the locked cage. We have the room which is temperature and humidity controlled. We have 2 different freezers, the -20 as well as the -80. So we have already all the facilities in place. And at many different institutions, which do not always have a research pharmacy, the local site investigator and his team would be doing would be performing these functions. So that is actually the entire thing I'm up here to appear before you.
So, and just to clarify a little bit more for the board, y'all were requesting an exception to having to register as a dispensing physician since these are investigational drugs. Correct?
That would be correct, yes.
Doctor, is the Board of Pharmacy involved at all?
The pharmacy is involved. In fact, they do almost all of our studies. It's just that in the last few months, since they've also had some shortage of staffing, they're not always able to come over to our medical mall. And we can actually involve them as well and work out a arrangement where if they are not available, we can dispense. It's just that right now we don't do it, and we wanted to make sure that we are perfectly legal in trying to accomplish what I'm suggesting.
So I guess my question was that with your research pharmacy that is at the medical mall? Is
So the research pharmacy is based out of the main campus.
Okay. That you're hoping to be able to function as a research pharmacy at the medical mall?
Well, they actually come over. So whenever there's a patient who needs at our clinic at GMM, they would come over from the main campus.
So, does the research pharmacy, they bring the investigational drugs to the medical mall, but the physician would be the one to dispense them? Is that correct?
Typically, yes. Typically, yes. There's also one other slight problem, which is that in today's day and age of rather limited budgets, the research pharmacy has their own fairly significant markup. And so in certain studies where we have young faculty starting off, and the grant is a very small grant, it is very difficult to make it work. And so that's the other issue, that if it's a small study and we have just a couple of dozen patients, it could be very well managed by our own division rather than involve the whole research pharmacy, especially as the entire operations is set up at the medical mall.
So does that mean that the investigational drugs would be purchased and delivered directly to the medical mall?
That's right, because we have the storage facilities. We have the storage facilities, and in fact, on the other side of the medical mall where the cancer center operates, I mean, they're able to store and everything. We have all the equipment that's necessary to store, to log, to do the accountability of the drug.
So are these investigational drugs, are they controlled substances?
No, we have not even touched a controlled substance.
Okay.
Yeah, we're just purely nephrology.
But you have your own system of, I mean, pharmacists, they have their systems for tracking, but
Right.
how would you track your inventory and stuff there?
Well, it would be fairly simple to do in today's day and age through a spreadsheet, and most of these investigational trials do provide a template of how to maintain these logs. So that would not really be a big problem.
Okay. Thank you.
Any other questions?
So
Yes, sir.
I guess how complicated would it be to just allow the research pharmacist to come to the medical mall to dispense?
That's the problem.
But I realize this board doesn't have oversight over the pharmacist, and we're potentially going to give you permission for
Right,
this.
yes.
And so,
Right.
but still just, if we're trying to be consistent with the checks and balances systems that we have in place.
Right. So I'm sorry, your question again is?
The research pharmacist at the main campus is handling your investigational drugs,
Currently, yes.
is what the letter says.
Right.
And so why can we not just bring that research pharmacist on the main campus over to the medical mall?
Usually because of logistical issues. They are often short-staffed, and it is, about a 15-minute drive away. And they actually deal with a lot of studies, right, with all the departments, all the divisions. And so this is not the only one they have, and it may not be very convenient at that point in time for them to come over on this particular Thursday morning, for example.
And so in terms of, of the oversight that the pharmacist provides at the main campus level, would there be any change in terms of how the drug is tracked
We'll be doing the exact same tracking mechanism. The oversight that research pharmacists usually provide is to make sure that the drug is stored at the proper temperature and the accountability is done properly. And both of those functions we could easily perform.
And these would be medications given in a bottle with proper labeling to the patient
Yes, yes, of
as they're
course.
walking out the door with proper instructions and.
That's right.
Mr. President.
Yeah.
Mr. Dossavoy, Dr. Dossavoy, what role does the IRB have in this situation? What is their stance on the pharmacy's interaction with the study and who can do what?
Typically, this is not something that the IRB objects to, because they deal with the ethical aspects of human subject research. And as long as you can provide them evidence that you have the ability to do the regulatory pharmaceutical part, pharmacy part, they usually do not have an objection.
To your knowledge, is this proposed mechanism being used at UMC at all, anywhere? Or has it outside of the pharmacy?
I believe it has been in the past, and at many institutions it is done because they may not have a research pharmacy. Research pharmacies and research pharmacists are quite expensive to maintain.
Yeah.
Right? Because that person will not be doing the usual work in the hospital.
Yeah.
And you all know how much pharmacists cost.
Right.
So many hospitals, many smaller community hospitals who are doing research don't have that facility, and they're able to do all this accountability themselves.
So the medical mall has been in place for quite some time. And certainly involved in studies that the greater campus initiated. Is there any precedent for this in other departments? It would be helpful for us to know that this had been done.
To be honest, I've been here for a little over 4 years, and I don't have that long of an experience here, so I do not know of any particular example.
Doctor, are you the chair of your department?
Dr. Michael Hall is the chair of our department of medicine.
Of nephrology.
I am the
You are.
division chief. Yes.
You are. Okay, very good.
So you're requesting an exception to the rule for dispensing physicians. Is that correct?
Yeah. So about 2 years ago, we passed rules that dispensing physicians had to register with this board and the Board of Pharmacy. And that he's requesting an exemption to that rule. And they have residents and fellows rotating through. It would be a lot of name changing and stuff. So.
But they don't have to register with the pharmacy board either, right?
Yeah, that rule is ours. And so if we give an exemption to it, then that would also exempt them from that as well.
And this would be for the nephrology department.
Exactly. I'm only requesting for our own division.
Well, are we ready for a motion?
We are.
I make a motion that we grant an exception to the rule for the nephrology department for registering as dispensing physicians for their research
Is there a second?
project.
Any further discussion?
Doctor, I would just say that if there's not precedent, there is now. And you did the right thing by asking instead of asking for forgiveness. So good for you.
Thank you so much, and I hope I don't have to come back for that second. Thank you.
All-
Appreciate it.
All in favor, say aye.
Aye.
Any opposed? Any abstentions? Motion carries. Thank you for coming to us.
Thank you very much. I appreciate your time. Thank you.
Moving on, item number 10, hearing in the case of Mehul Piyush Dixit, MD, Jackson, Mississippi medical license 21228. Paul?
Yes, sir. Dr. Dixon will not be appearing today. Widely publicized that there are related criminal proceedings as well as the licensure proceedings. I've discussed this on the phone numerous times with his attorneys and received an official formal request yesterday from Dennis Horn, one of Dr. Dixon's attorneys, for a reasonable continuance in light of the pending criminal matters. I would recommend that the board consider continuing this matter until the January board meeting. That's 8 months out. That would give us a chance to get a status check. It may require additional extension at that point, but it'll allow the board to know what the status of the criminal proceedings are. All other provisions of the temporary order of suspension would remain in effect and in place until this board ultimately resolves them after a year. So Dr. Dixon has requested reasonable continuance, and in light of due process concerns, we agree that it is the recommended course, is the right course, most prudent course.
Thank you, Paul. I'll entertain a motion for continuance of the case of Dr. Dixon.
So moved.
Second.
Any further discussion? All in favor, say aye. Any opposed? Any abstentions? Motion carries. Moving on to item number 11, informational purposes for Dr. Almeida Mobile, the surrender of medical license.
Yes, sir. Again, doesn't require a board vote. Board members will recall that Dr. Almeida was put under consent, or was put under a restricted license from some severe restrictions within the last year. Dr. Almeida surrendered his Alabama license about a month and 6 weeks ago, and he has now surrendered his Mississippi license. So he's no longer licensed in either Alabama or Mississippi.
Thank you. Moving on to item number 12, hearing in the case of Gregory A. Alzine, MD, Meridian, Mississippi, medical license.
We pronounced it a lot of ways. I think his attorney pronounced it Ozan.
Okay.
This is the first motion for continuance, and we are working out the terms of a proposed consent order to Dr. Ozan's counsel that we expect to present to the board at the July meeting.
Is there a motion? There's a motion for continuance of this case. Is there a second?
Second.
Any further discussion? All in favor, say aye. Any opposed? Any abstentions? The motion carries. Moving on to item 13, here in the case of Feluso A. Falco-Reed, MD, Cleveland, Mississippi, license number 23725.
Dr. Thackeray is represented by Doug Mercier. This is the first motion for continuance. It is a complex matter involving cardiothoracic surgery. So we expect that if it does go to hearing, it will be extensive testimony and evidence. Again, first motion for continuance, and we would also recommend that this be continued to July.
Is there a motion?
So moved.
Again.
Is there a second for continuance? Any further discussion? All in favor, say aye. Any opposed? Motion carries. Moving on to the hearing, 14, hearing the case of Michael L. Sanders, MD, Ridgeland, license number 1970.
There have been multiple requests for continuance of this matter. I mean, not only by Sam's attorneys, but from myself, from me. This is a matter of agenda or docket control and workload. The hearing for Dr. Sanders, we would anticipate a full hearing goes forward. It will be lengthy and extensive, and therefore we request that this be continued to the July meeting.
There's a motion for continuance. Is there a second?
Second.
Any further discussion? All in favor, say aye. Any opposed? Yep. Any abstentions? Motion carries.
Item 15 is our last of these quick items. The case involving Dr. Stephen D. Sutter, MD, again, represented by Doug Mercier, who has requested this continuance. I agree. This is a complex prescribing case. It will involve testimony from multiple medical experts. And again, we asked that it be continued to July to allow the board a reasonable docket, a reasonable agenda, but not an overwhelming workload for one meeting.
There's a motion for continuance. There's a second.
Second.
Any further discussion? All in favor, say aye. Any opposed? Motion carries. Moving on to item number 16, Rachel N. Hole, MD, license number 21690, approval of consent order.
Make sure Dr. Hall is. Reintroduction. Board received a complaint from Dr. Hall that improperly accessed medical records and violated HIPAA. After investigation, the executive director offered terms to Dr. Hall for a consent order, and she is here today asking the board to accept those terms. So again, this is about wrongfully accessing medical records. And this time I'd ask that Dr. Hall be sworn and takes the stand. So Dr. Hall, at the time this happened, where did you work?
Rush, optional rush,
Okay. What is your specialty?
pediatric.
Do you currently work at Rush?
Yeah. I was terminated on September 6th of 2020.
Is that related to this incident?
Yes.
Dr. Hall, if you would just explain to the board how this came to happen.
So on June 1st of 2022, I received a phone call from a young lady. Who stated that she was pregnant by the young man that I'm supposed to be married. Of course, he denied it, and to verify whether she was or not, I did access this young lady's chart.
Did you not know that that was forbidden by HIPAA, by
I
law?
did, yes.
How many times did you access her chart?
Twice, I believe. Two, three. I didn't.
Before I move on to specific terms of the consent order, do any members of the board have any questions at this point for Dr. Hall?
Dr. Hall, I'm David McClendon, President of the Board, Internal Medicine, Ocean Springs. What are you doing now?
Nothing. I was attempting to open my own practice after, but it didn't work, so I closed it.
Have you ever had any other actions against your license or privileges at any other hospital or in the past in any other situation?
Ether.
Where'd you go to school?
That was cool. The University Medical Center here in Jackson,
Where did you do residency?
here in Jackson, at that time.
Any other questions?
What are your plans after this proceeding?
If the consent order is accepted, I plan to reinstate my license and hopefully find employment later.
But you don't have anything right now.
I apologize for not directing that request to you this morning. I realized that that was procedurally improper. Dr. Hall, I would just like to go through, in terms of, you have, signed the consent order, you've reviewed all the terms, correct?
Yes,
You have to say yes.
yes, sir.
Okay. And I just want to go through the, sanction part, the part of the, terms of the consent order. On page 2 of the consent order, number 1, the license practice medicine state of Mississippi will be suspended for a period of 6 months with the suspension immediately stay. Do you understand what that means? So you understand that it would not be an active suspension, but it's not that called probation, but if you were to commit any other violations during that time, the suspension could become active. Yes. Is that
Yes, sir.
I'm sorry. Okay, you will attend and successfully complete continuing medical education course in areas of boundaries and medical ethics. You agree to that?
Yes, sir.
3, bit of boilerplate, but it is important. Licensing usually will obey all federal, state, and local laws and all rules and regulations governing the practice of medicine.
Yes, sir.
Item 4, you shall reimburse the board for all costs incurred in relation to pending matter pursuant to section 732530 of the Mississippi Code. Said amount not to exceed $10,000. Licensee shall be advised of the total assessment by separate written notification intended to the board of a certified check of money order on or before 40 days from the day you receive the assessment.
Yes, sir.
Understand that if the board does not approve the consent order, that the board could approve the consent order. The board could offer a consent order on different terms, or the board could reject the consent order and pass it this matter, go forward to a full disciplinary hearing. You understand that?
Yes, sir.
Paul, how was the initial infraction reported?
We received a patient complaint, and we, on investigation, and I'm gonna, if I get it wrong, I'll let Brad Estes as the investigator on this, mind me, but at some point during the investigation, he got into contact with the officials at Rush. They had noted the breach in their own records and had, internally investigated. And ultimately, Dr. Hull was terminated. So it first came from a patient complaint, and then the investigation confirmed the details with Rush.
I'll entertain a motion to approve the consent order.
So moved.
Is there a second? Any further discussion? All in favor, say aye.
Aye.
Any opposed? Any abstentions? Motion carries.
Thank you.
Thank you, Dr. Law. Moving on to item number 17. Massey Headley, MD, Mississippi Medical License 18856, approval of consent order.
Okay, please. First, I'd like to introduce Dr. Headley and his attorney, Tim Sensing, Watkins and Eager firm. We're here presenting a consent order to resolve a case that has been going on, an investigation that's been going on for many months. Case grew out of the Dr. Headley's ownership and involvement with the operations of facility, core hydrotherapy, provide IV therapy as one portion of the business. Hormone replacement is another part of the business. And I would like to point out what we the Lord learned or received a complaint that the patients, IV patients were being seen, or were not being seen, but were receiving IV therapy without a qualified healthcare professional with prescribing authority being present, performing an adequate physical, and actually prescribing medications. When we first investigated this and filed an affidavit, summons an affidavit against Dr. Headley, we had limited information. It was understanding that Dr. Headley was the only healthcare professional that was involved. And we learned that during further investigation not to be the case. There were several mid-level practitioners who at times were involved with this practice. There was, Dr. Headley is not the only licensee of this board involved in this investigation. However, I do want to emphasize that due process gives each licensee an opportunity for their own hearing, to be heard on their own behalf. And so we need to, and I would recommend that the board focus on Dr. Headley's actions and conduct and his wrongdoing, which I believe he's going to admit a good bit. Yeah, he's going to go on the stand and tell you, but just would like to keep this focus on Dr. Headley, because if we don't, we risk violating the rights of the other licensee. Mr. Simpson, do you have anything like to say to start off?
Now proceed. I'll just be brief. Thank you guys for your time this morning. As Paul said, I represent Dr. Headley in this, and I really just want to communicate on his behalf, and you will hear from him that we're here in the spirit of obviously cooperation, and he's here to acknowledge the mistakes he made in his practice. He's been a Mississippi physician for 25 years with no blemish on his record of any sort before this, no med mal cases or anything like that. He's married with 2 kids in college and 1 in high school. He's here to tell you that he will tell you that he's regretful and embarrassed for the situation he's put himself in. He's learned a valuable and costly lesson through this process. I want to tell you briefly, very briefly, about how he got here and the lessons he has learned. He was pitched, he's a primary care physician, and he was pitched an investment idea from someone for a medical facility that's separate and apart from his primary practice that he's done for 25 years. Unfortunately, as you guys may well know, but many physicians do not know, when you invest in a medical facility, it's a different animal. And I tell my doctor clients, I have for 15 years, if you want to invest in something, you ought to think long and hard before you invest in anything involving medicine, because you're just held to a different standard. And many physicians don't realize that until they find themselves in the middle of it. And Dr. Headley did not. He invested in this particular business without guidance from a lawyer and without really understanding all that goes with being a doctor who invests in a medical facility. He was naive and maybe a bit casual in his investment choice. And he realizes now that he made mistakes, some of omission, some of commission through the process. And best way I can describe it to you generally is that he allowed the lines to become blurred between being a passive investor and being someone who was overseeing, or at least at some level supervising, what was going on at the clinic. And that happened gradually over time. It was not immediate. Questions here and there from people. And but the reality is, and we're here to tell you, is it did happen, to some level. And he realizes that now. He did not realize then that that was going to cause him to run afoul of board regulations and statutes, but he certainly does now. He was naive a little bit, and he'll tell you about some folks he trusted, both those who pitched the idea, who, although they were wrong, swore they understood the compliance issues associated with this clinic. He trusted some others who were also responsible for directing and managing the clinic. I don't tell you that to try to shift blame or to say that he's not what he is, and he will tell you that. But he was, again, naive and not understanding his duties. He realizes now, he didn't realize, and he realizes now, there were standards that he has to meet as a physician, even as an investor and quasi involved in a clinic, that he did not meet those standards. He takes full ownership of that now. He didn't have intent to violate board regulations or statutes, but he did. And you'll hear him tell you that. But rather than Paul and his group, his team, and Dr. Cleveland did a good job with their complaint and their investigation. And while we don't agree with every single fact in there, we're here to tell you we agree generally that Dr. Headley violated these regulations, and he wants to take a discipline. It's been an eye-opening and sobering ordeal for him. That's one of the reasons you'll hear Paul tell you about a portion of this consent order that we voluntarily offered to the board, and I think it's probably something new, but one of the provisions of the order that I think is important, speaks to his humility in this, is that he is willing to or wants to stand up in front of his peers at different events. I think 2 of them is what we have in the order, and tell his story and tell about his naivety and his maybe casualness in this, and to explain to them how he got into this, where he is, and hopefully educate his peers on how maybe they can avoid that. And as you guys know, as physicians, there's not many things more humbling than to stand in front of your peers and own your mistakes and say sorry for them and help others try not to make them. So I think his willingness to do that speaks volumes about where he is in this process. And so we ask that after you guys hear the terms of the order from Paul and hear from Dr. Headley, we ask that you accept the consent order. And he very much wants to, he's learned a great deal from this, but he wants to put it behind him and eventually move on with his practice. So we appreciate your time and attention today.
I call Dr. Headley to stand. Dr. Headley, you stand up over here and face court reporter and be sworn, and then you come over here to the witness stand. Dr. Headley, Dr. Headley, if you don't mind, tell the board your full name and your practice, what your specialty is.
Massey Hunt Headley, family medicine.
Tell us about your education and training.
Yeah, I attended University of Mississippi undergrad, UMC medical school, UMC residency, family medicine.
We're certified in family medicine.
Yes.
So Dr. Headley, am I correct that you have never been in disciplinary trouble before?
Yes, you are correct.
Never had any problems with your credentials or any hospital, anything like that?
I've never had any problem.
Dr. Headley, you and your wife invested a substantial amount of money in this facility core when you were approached about this venture, correct?
Yes,
How much money did you and your wife invest?
$120,000.
Do you and your wife currently own any interest in core? How did you?
No,
Okay. How did you divest yourself of that interest?
sold it.
But tell us how you got involved with core. You had a business partner. There was a non-physician, non-licensee running it, and it was the co-owner.
Yes, yeah, and he approached me and asked me if I was interested in being a partner, and
I told him yes, and we went forward from there.
If you don't mind, just go ahead and just explain how that progressed, your ownership, who was involved in the facility?
Yeah, at that point, there was a medical director and there was a nurse practitioner. And that was back in like 2018. And then it just progressed from there and grew and added on nurse practitioners and different services.
Did you have any background or experience in this type of practice?
No,
So was it 2019 or 18 when you invested?
yeah, it was 18 as I recall.
Okay. So am I correct that COVID put a crimp in operations for hydrotherapy? Correct.
Yes, yeah, that's been nothing going on for months.
Okay. And am I correct that there were several different mid-level providers at various times in core? But do you agree with me that there were times when there were no mid-level providers?
As I recall, there was a nurse practitioner there until I think maybe at the end of, let's say, 21, maybe.
You would agree with me that the staff was fluid. It
Yes.
fluctuated.
Yes,
A lot of turnover.
yes.
When did you officially become the medical director?
I became the medical director in July of 22 until August of 22 for about a month period.
And do you recall providing our investigators with a copy of the protocol for IV therapy used it for?
Yes,
Okay. Do you recall that protocol permitted paramedics to administer the IVs?
I remember that was what I was told was and had been under the previous medical director as allowable. So
Are you aware now that that does not comply with Mississippi law, that paramedics are not allowed to do that in clinical settings?
yes, sir, I'm very much aware of that.
And so you understand why one of the charges in affidavit was assist in the unlawful practice of medicine.
Yes, sir, I do.
That was related to the people who were actually administering IVs.
Yes, sir, I understand.
Do you also agree that there were patients during this time period? Let me back up a second. Good. Explain to the board the intake process for, I believe, referred to not as patients, but as clients for the IV side. Is that correct?
My understanding of the intake was there was always a nurse practitioner there until that point, at which in December of 21, there wasn't, and that at that point, people would come in and they would give whoever was there at the time would get a history and decide what they needed in conjunction with the patient.
History was taken just through a questionnaire. Is that right?
That's my understanding.
Okay. Were any lab tests ever conducted for IV therapy? Before IV therapy?
Not to my knowledge, no.
And do you agree with me that for at least some patients, during this time, an undetermined number did not receive a physical examination before they received IV therapy?
I know they were supposed to, but yes, there probably were some. Yeah.
We'll get into the specific terms. You understand the board will have an opportunity to ask you questions, as well as Mr. Simpson will also have an opportunity to ask you questions if he chooses. But there isn't for this board an unusual time in the consent order. That is,
The order calls for, the order calls for a 6-month suspension of your license. But if you speak at two continuing medical education activities or seminars, which would have to be board approved to the executive director, do you understand, correct?
Yes,
You understand that the content of your presentations, including any slides and presentation materials, will also have to be approved in advance by the executive director.
yes, I understand.
Okay. And in exchange for doing that, 2 instances, we give you the opportunity to reduce your suspension 1 month for each presentation.
Yes, I understand.
And I just want to make sure you understand that that is, as I'm not, I think this is the first time, it's the only time, I believe it's the only time it's ever been proposed. Certainly, it's a new avenue for the board to consider. But of course, you know, I'm glad that, you know, the board are you're the ones that have to decide the appropriate discipline. But the executive director, when Dr. Headley and his attorney, Sensing, presented that as a proposed term, the director believed it was worth considering. It might provide a benefit. And certainly it merited bringing it to the full board to consider. So Dr. Hadley, if you give those speaking, if the board accepts the order and you give those speaking, well, back up. The board accepts the order, the license is suspended for 6 months. Understand?
Yes,
Okay. And then if you do make these speaking events, and within that time, you can cut your suspension, the 6 month off, and then the second time you can cut the 5th month off. So it end up could be as little as a 4-month suspension.
yes.
If you give these talks, who do you propose that you talk to, and what do you intend to tell?
I want to talk to other physicians and chronicle my mistakes that I've made and try and help them not fall into the same pit and guide them and let them know how serious the board is about infractions, and you can't claim you don't know. And I understand that. And I'm very sorry for what I've done here. And I want to express that. And I'm ashamed to be here. And I'm sorry I broke these rules. And I can help other people, I'm certain of it, with these talks and make sure that they understand how precarious this can be and that physicians really should avoid being involved in medical related businesses if at all possible.
Okay. I appreciate you directing your attention to me, but if you would, speak to the board. Because they're the judge and jury.
Yeah.
Can you tell me specifically what mistakes? We heard from your attorney, but can you tell the board specifically what mistakes that you feel like you made that led you, put you in this situation?
Yeah, I did blur the lines between being a physician investor and a supervisor. I did not do my due diligence in understanding what standards that the board holds physicians to. And I made mistakes as far as letting other people make decisions for me and not really understanding the seriousness of what was going on around me.
Did you allow medications, including the IV medications, to be ordered using in your name, using your DEA number when ordering from pharmacies?
Now, the only things I ordered from pharmacies would have been things that didn't require a DEA, like IV bags and vitamins. Now, the DEA number was on there in case you needed to order something that was controlled. But
you allowed another person at the clinic to do that. Did you, or let me ask you, did you approve each purchase, or did you allow your co-owner or the clinic administrator to decide what to order?
I signed off on some purchases.
Dr. Headley, do you understand that a 6-month suspension, especially with if the board approves speaking provision, that's actually in retrospect, considering the board's past decisions, that is a very light punishment for the infractions that you've committed.
I do understand and I'm very thankful and I feel like I've been treated exceptionally fairly at this point. And I'm hopeful.
Didn't have my papers in order, I do apologize. Let's talk about the specifics of the consent order, Dr. Headley, which you have signed and
Yes, sir.
your approval. And you are asking the board to approve this here today.
Yes, sir.
Um, Paragraph 1, the first licensing certificate is hereby suspended for a period of 12 months. It says suspension stay after 6 months. Which that's kind of like a suspended sentence. That you would have a 12-month suspension, but the active part of suspension would be 6 months.
Yes, I understand.
Paragraph 2, provision we were speaking of. Licensee shall speak or present at 2 physician group meetings or medical student meetings approved in advance by the board, including substance and content regarding his case, the importance of honoring supervisory oversight responsibilities of mid-level providers over the next 6 months. Completion of each speaking engagement would stay an additional month of Dr. Headley's remaining active suspension. By completing 2 speaking engagements, Dr. Headley's 6-month active suspension could be reduced to as little as 4 months. That's the term that we've been discussing, correct?
Yes,
Dr. Headley, that seems like that is going to be a very tough obligation to fulfill. Do you feel that you are ready for that?
yes, certainly do. I can do it. I have no doubt.
Speaking of one's peers in many fault, that's got to be one of the toughest things anyone ever has to do.
I can do it and I think I can help folks avoid this. It's that I've gotten myself into here. I do.
Item 3, licensee, any of family members with the best themselves of all financial interest in cord crop therapy. You've already done
I've
that.
already done that.
4, licensee agrees not to practice in the area of hydration therapy for life at this practice.
Certainly.
Item 5, licensee shall within 6 months of the acceptance and approval of this order successfully complete a board approved, continuing medical education course, specifically the CPEP Pro course, covering the areas of ethics, boundaries, supervision, and mid-level providers. You agree to that? And of course, you would need to provide proof of that completion and to our compliance officer. Item 6, you agree to obey all federal, state, and local laws, all rules and regulations regarding the practice of governing the practice of medicine. You understand that any further acts of misconduct of any type will result in further action.
I understand.
In item 7, you expressly agree that you will not seek an appearance before the board prior to the completion of the terms of this order. And further, you agree that the terms and conditions of this order, once executed, may not be appealed or reconsidered.
I understand. Yes.
Item 8, licensee shall reimburse the board. I'm not going to read it. This is a very familiar provision of the board. You will reimburse the board for costs up to $10,000 statutory limit, and that you will be provided with an itemized statement of exactly what those expenses are.
Yes.
The other terms, I don't think we need to go into, but they're standard and familiar to the board that if the board does not approve this consent, you understand that it will have no force and effect, and that this matter will be set. Well, one of 2 things may happen. The board could offer you a consent order on different terms. If you can consider, do you understand that?
Yes, I do.
Or the board could accept the consent order, or the board could reject the consent order, set this matter for a full hearing.
I understand.
I think
Any questions?
Dr. Headley, have you had a chance to check on the required CMA? Do we know when that's available?
No, sir, I haven't had a chance to check on that.
Yeah, I would encourage you to try to, I know you want to get this behind you as soon as possible, but I would encourage you to try to get that CMA as soon as possible, so you can incorporate that into your, your story with
Sure.
sharing with the
Yes,
physicians.
sir, I will. I'll do that.
Doctor, what hospital do you have privileges at?
Baptist,
So certainly think of several meetings within a large hospital system and medical staff meetings and different things that maybe a chief of medicine or chief of staff is nice to may help you get in front of a large group of physicians to share your story.
yes. I think that's a good idea.
Dr. Headley, one thing I want to make sure the board understands. You talk about blurring the lines. A big part of that line was responsibility for supervising mid-level. Correct?
Yes,
Okay. And again, while you're not the only licensee involved in the operation, there were times when you told the clinical staff, if you have questions, call me. Did you not?
I did. I told them if they couldn't get in touch with the medical director to call me. I did.
And did they call you?
On occasion, they did, yes.
And you did act, even though you were not in name your supervising position, you in effect acted as a supervising position, did you not?
That was a mistake I made, yes, sir.
And do you understand the significance of a physician signing his name?
I do now.
Well, let's talk about physicians sign orders, right? Physicians sign prescriptions, physicians sign reports, recommendations. And you know that other physicians and other healthcare providers are relying on your signature, your honor, and your quality as a physician to make their own decisions, correct?
Yes,
And so you understand that it is vitally important that you know exactly what you're signing and that you understand exactly what you are committing to before you sign any sort of document related to practice of medicine. Is that correct?
I understand. Yes, that's correct.
Any questions for you?
Any other questions from the board?
Board doesn't have any other questions. I would waive and closing statement. That's what I.
I'll entertain a motion to approve the consent order for Dr. Headley. There a second?
Second.
Any further discussion on the motion? All in favor, say aye.
Aye.
Any opposed? Any abstentions? Motion carries. Paul, let's take a 5-minute break.
Yes, sir.
Is Dr.
Yeah.
He's presently good. Good. He's under
We're back in full board meeting. We'll proceed with item number 18, hearing in the case of Linda Purdy, MD, Brentwood, Tennessee, Mississippi medical license 2595.
I get so confused sometimes. Boy, the name is Laura Purdy, not Linda.
And I apologize today. So, I didn't write it, but I did give it to him. Got it wrong. But it was too late to correct it for all of the problems. I didn't apologize for that. It is Laura Purdy. And please the board, this matter, came up with the board with a complaint that Dr. Purdy, understanding in the Mississippi practice, was the telemedicine and understanding she practices. She practices in all 50 states.
Start again.
Okay. We received a complaint that Dr. Purdy was practicing telemedicine in Mississippi and was violating our telemedicine regulations. My understanding, Dr. Purdy resides in Tennessee, but practices telemedicine, is licensed to practice in telemedicine in all 50 states. The specific of the complaint were from a patient. Patient complained that the physician prescribed her Ozempic over an app after brief messaging for $50 cash, no audio visual contact. And the patient went on to say that maybe legal, but I don't think it's good care. The patient specifically said that she asked for Ozempic and was prescribed Ozempic. There was no discussion of how to use medications or side effects of the medication. No one asked if she had history of pancreatitis or thyroid cancer. She was obese, is not diabetic. So that's the complaint that came in. Our investigation showed, and I'm sure Dr. Purdy can explain more detail, is that this is basically text messaging that's I think the system is maybe Push, or that may be the name of the company, but they patient goes online, and again, I know Dr. Purdy will correct me if I get these details wrong, but goes online, fills out a questionnaire, and then there is some back and forth texting, asynchronous, store and forward as you were. The incidents in question, now, we do not know exactly how many, patients Dr. Purdy may have treated in Mississippi via telemedicine, but we had found three instances very quickly and asked for medical records. And to her credit, Dr. Purdy did not deny the facts and did not deny, once she understood the regulations, that her conduct violated our telemedicine regulations. Sure, she'll tell you that. But this occurred, like the one incident I think was in February of 2022. So this board, a little bit of history, but we're all clear on it. The board's old telemedicine regulations were in effect in 2019 when Dr. Purdy first came in Mississippi. Then we had COVID, the COVID proclamations. And so there were some relaxations of certain requirements of the board's telemedicine rules. Then once the telemedicine emergency ended, the COVID emergency ended, the governor rescinded the state of emergency. This board's old regulations snapped back into place. And the board changed that last year. I believe it was in March, we presented proposed regulation with some relaxations. The board was not satisfied with some of the terms, such as allowing pure store and forward technology to be used for telemedicine. So the board provisionally passed the new telemedicine regulations in May, finally passed them in July, and the OLRC approved them. But this case, Dr. Purdy is charged under the old regulations. That is what was in effect at the time. So the new regulations actually specifically explain a little more about some of these situations. The new regulations specifically say text messages not okay. The old regulations were not quite as specific, but did make it clear that use of just a questionnaire was not enough. That patient encounter had to be able to duplicate the information, or examination had to be able to duplicate the information that could be obtained from face-to-face traditional encounter. So that's why Dr. Purdy is charged under the old regulations. But at the time she was treating those patients, those were the regulations in force. As I expected, I'll let Dr. Purdy's attorney, lay out their case. But as I understand it, Dr. Purdy is not denying the violation. She's not denying the facts. She wants an opportunity to speak to the board and explain to them, her practice, the details of it, and I'll give this board an opportunity to ask her, very specific questions. This board has asked very detailed questions about telemedicine. You're all intimately familiar with those regulations. This hearing officer, at this time, I would yield the podium to Johnny if he has any comments.
Thank you, ladies and gentlemen. I'm Johnny Chapman, and I have been here before for some, or not all of you. I feel under somewhat more pressure today because I'm being critiqued by my son sitting back there. I don't think he'll learn a whole lot, but anyway, he's doing this a long time. It's kind of hard to articulate. I will point out one thing that Paul said that I believe is in error. The patient did not complain to this board. A physician complained to this board. The patient was not unhappy with the care he received, but it was the physician. And we have no problem with that. No, Dr. Purdy does not deny the factual allegations. Certainly she did what the affidavit did. What she is here today is to open herself up to you to every question you may have about how she does things, what her practice has evolved into since then, and ask you to consider those things when considering what decision you may want to make today. We understand we could have done this a little differently, but she does not want to be confrontational with you. She wants to be cooperative and work with you because she is licensed to practice in 50 states, and that's not an unarduous task to have that happen. I would point two things out to you that are in the exhibit that Paul has, that he's about to offer, which is your records of this, and that's page 71, which is a fairly long email to Brett Estes regarding when this began and what she had done and sort of her background, and a second beginning with page 73, which were the standard operating procedures. She was in the process of revising when all of this started. Understand, Dr. Purdy is well aware of regulations. She spent 14 years serving this country as a doctor in the United States Army. She was early on in telemedicine because that's what the Army did. If she was at Fort Benning or Fort Bragg, and she was dealing with medics in the field in Afghanistan or the Middle East, then she communicated with them with telemedicine. So she is aware. She understands that she was not complying with Mississippi rules, She has made considerable efforts to be sure she is complying now. She is available and open to furnish any and everything to you may wish to see about any patient she has served in Mississippi. When she received the complaint or the affidavit, it's not really a complaint, the affidavit on April 17th, she ceased caring for all Mississippi patients. She had 155 at that time. 15 of them have requested to be transferred. The other 40 have made no request, but she is serving no Mississippi residents at this time. So with that said, go ahead.
I do apologize, and I agree that, it was in fact patient complaint to a physician. The physician actually filed a complaint, so that's why the details were a little mixed up. I apologize. But, again, Brett Estes, our investigator, kept me straight. At this time, I would offer as a collective exhibit, documents bearing face numbers MSB 1 through MSB 82, and ask if there's any objection. And just to summarize, so doctors know, there's a redacted copy of the complaint that was received by our electronic system, the summons affidavit. And then there are some emails between Mr. Estes and Dr. Purdy where they were giving requested records, and she was responding. There are 3 patient charts. And then there is, an email from Dr. Purdy to our investigators and providing standing operating procedures, a letter, there's the SOP, and a couple of other emails between Mr. Estes and Dr. Purdy. So again, without objection, I would ask these be, these are electronically available anyway, so I was making this. Yes, that's a copy. I have produced the number of trees that I can use in past one.
Thank you.
Get an next thing.
Yes, sir. I call that the party to stand and she's sworn. Stop. But it's that problem, so don't let it start. Dr. Purdy, please tell the board about your training experience in practice.
My training experience in the practice of medicine. Well, I direct accessed into the Army in 2007 and went to the Uniformed Services University, which is the service academy in Washington, D.C. I trained at the old Walter Reed Bethesda Naval Hospital and several places throughout the U.S. Then I attended and completed a family medicine residency at Fort Benning Army Hospital in Columbus, Georgia. And after that, I worked as the battalion surgeon in the 91st Civil Affairs Battalion, which is a misnomer. I'm not a surgeon, but that's what they call the medical director. And there I did a lot of travel medicine, remote medicine. My unit rapidly deployed to Africa every 6 months. And I did a lot of remote care and infectious disease. And I was also the PCP for the 300 people in the unit. Then I moved to Fort Campbell. And I started out as a hospitalist working urgent care on my off nights, adult and pediatric. And then I was the battalion surgeon, which is a misnomer, for the Warrior Transition Unit, which now I believe they call it the Soldier Recovery Unit, but it's for, wounded soldiers and veterans as they're getting injured and transitioning out of the Army, which that's actually where I first cared for Mississippi patients in person when the 155 demoed. That's where they went, was Fort Campbell. So during that time, I started moonlighting, if you will, for MD Live, which is a large, now owned by an insurance company, telemedicine company that was 100% synchronous video and phone only. I worked there for 2.5 years, was the first full-time employed physician that they had and medical director. So I did that. I had 20,000 phone and video patients when I was there, and I had my third child, so I left. Had a baby. It was hard to do. And then I worked for Hims and Hers as the national medical director and the PC owner, which was my first experience with what you refer to as asynchronous or non-real-time two-way, which is still two-way, but it's just not in real-time care. Also have worked in a variety of capacities, advising, consulting, attempting to help companies get off the ground and chase things like what is the standard of care through COVID, and then also in the post-pandemic environment. So the clinic that we're talking about today is my first attempt at starting my own, if you will, outside of the umbrella of another company. And if you don't mind, if I explain how it works, so I have a choice. So Push is just an EHR, and so it's completely modular, and I can choose how to undergo the visits. So thankfully, I have the opportunity to evolve and develop the processes, which I have definitely done before and after this complaint, which we could talk more about if you would have specific questions. I hope that answers your question.
It does, and I've got a few more questions in a minute where I want to talk about your reply to the affidavit. Bottom line is, you agree that with at least some of the Mississippi patients, whose chart you provided, you use the Push app, and an online history form. You did not have any real-time audio, visual, or even just audio. You did not have that with Mississippi patients. Is that correct?
That's correct.
And you now understand that that violates this board's regulations, do you not?
Without question, I do.
And you specifically prescribe, in addition to other care and treatments, but you prescribe Ozempic. Was it just Ozempic, or is it Ozempic and Wegovy to Mississippi patients? Do you recall? I'm not trying to.
For these specific patients or just in general?
Well, so at these specific patients, and then I'll ask you the same question about general. For these specific patients, did you prescribe Wegovy or Ozempic?
Yes.
We did not perform a physical examination of them. I know that you have the capacity to labs, or that's my understanding. Do you know if you did any labs with these patients before you prescribed them with the semaglutide medication?
No, although if you read the messages, there were requests for labs, and there were some instances where they provided the information.
And I agree, and I don't know, and this is the question, but basically with the messaging system, you can do that with your phone, right?
Correct.
Do you do it with your phone, or do you use a computer, or both?
99% of the time it's computer.
Okay. All right. But So the patient, I think, start from when the patient reaches out to your practice and bring me forward as to how you, in the intake process, and then how you be texting. How do you take the history, that sort of thing,
Do you mean at the time of the complaint or do you mean current day?
at the time of the complaint?
So at the time of the complaint, the patient, so the way that it works is that PUSH does the lead generation. So I do not recruit my own patients. The patients come to what is technically the EHR that services the medical group, and I am in the medical group. And the patient comes and says, I am seeking a particular medication, or I am seeking care for a certain condition. So usually they are looking for something specific when they come in. Then the patient is assigned to a clinician, which may or may not be me, and I have the choice whether to accept or to pass on the patient. So for an example, I do not prescribe any controlled substances in any state in the country ever. And if I see one of those come through, I pass on it, to give you an example. So once that happens, the patient fills out an intake form, which is designed by PUSH corporate, but there are a series of additional questions that I ask on top of that. Then usually there is a back and forth discussion, which you can see in the exhibit. I think there's a couple pages of back and forth messages. So non-real-time two-way dialogue regarding options, choices. You'll see a request for A1C, you'll see a request for weight. You'll see me tell the patient that they're welcome to reach out to me with any questions or if they have side effects. And then it's a matter of figuring out where to send the prescription and how to go about helping the patient get it, because these are expensive medications, especially if they're used off label. And so that's a discussion that's had as well. Then the prescription is transmitted, which is generally 30 days at a time. If the patient requests 90 because insurance will cover it, then I'm willing to entertain that because these are thousands of dollars a month. But the patient is required to follow back up with me for weight checks, and they're asked about side effects, and it's considered to be an ongoing relationship. The patient is also, of course, permitted to come back to me for anything else that they may need or want in the meantime. For example, if they had strep throat or something like that, this is not a relationship that is designed to be short-term or temporary. They're considered a panel and they belong to me unless they choose to be reassigned or I release them, like the 15 patients of the 155 who requested to be reassigned.
I understand that you've changed your practices since the receipt of the summons and affidavit to comply with Mississippi regulations, correct?
Yes.
Okay. Before that point, you said you had the option to choose what method to use. In these particular cases, you chose to use PUSH messaging app, correct?
So PUSH is the EHR on which my whole clinic is that is the EHR that I use. They do have an app, but it is an EHR.
Yes, and I apologize.
Just like Epic EHR has an app, it's an EHR.
What's the app called?
PUSH Health.
Okay, so PUSH Health. All right, and I believe you testified that you typically use a computer to respond to the messages,
My
but
preference.
you could do it from your phone.
Yes.
Right, and this is in the affidavit, but again, because the board's regulations have changed in this area, several times over the last few years, I can't be sure that we're clear on what we're talking about. The regulations in effect at the time you saw these patients require a valid physician-patient relationship must be established. The elements of the valid relationship are: one, verify that the person requesting medical treatment is in fact who they claim to be. How did you do that?
At that time, there was no method of doing that.
Okay. B, conducting an appropriate history and physical examination of the patient that meets the applicable standard of care. Do you think that you didn't perform a physical examination of these patients, correct?
Only to the extent of asking them things such as their biometric data and labs if available.
C, establishing a diagnosis through the use of accepted medical practices, i.e. a patient history, mental status exam, physical exam, and appropriate diagnostic and laboratory testing. So again, just confirming, you said that you could order labs, you have requested, say, A1C is one that you mentioned for patients through the messaging app. And you could get them, how would you go about, if you needed a lab test, how would you go about getting that?
I have an integration request.
All right. Item D, discussing with the patient the diagnosis, risks, and benefits of various treatment options to obtain informed consent. Before the investigation began, were you complying with that regulation?
Not across the board. So it was, instead of me being proactive to share the information with them, it was more along the lines of receiving the questions from the patients and answering them as they arise in the old system.
Don't you have an obligation in informed consent to anticipate at least some of the patients, the usual questions, the most relevant questions, and provide that information to your patient before you prescribe a medication?
I do.
Ensuring the availability of appropriate follow-up care, I assume that would be through another visit with you or another provider if you passed on the patient. And do you maintain complete medical records available to the patient and other treating provider? Okay. And then last, there's another provision, Rule 515 of the board's regulations at that time said, other exams may be appropriate if a licensed healthcare provider is on site with the patient and is able to provide various physical findings. The physician needs to complete an adequate assessment. However, a simple questionnaire without an appropriate exam is a violation of this policy and may subject the physician to discipline by the board. Before the investigation began, were you in compliance with that regulation, or you were in violation of that one?
Yes.
And there were two charges made in the affidavit. And as I understand your reply, you do not contest the first charge.
I do not.
Right, which specifically was licensing violated regulations, etc., by failing to establish a valid physician-patient relationship and utilizing the questionnaire and doing the physical examination, all in violation of Mississippi Code 73-25-29-13. You admit that, correct?
I do.
Okay. But you do seem to take issue with count 2, which it reads, based on the foregoing, licensee is guilty of unprofessional conduct, which includes but is not limited to being guilty, includes but is not limited to being guilty of any dishonorable or unethical conduct likely to deceive, defraud, or harm the public, all in violation of Mississippi Code annotated section 73-25-29-8D. Sorry, get so fast. And 73-25-83A. Is my understanding correct that you dispute that?
Yes.
Do you have any information about how this board has for decades treated violations of its rules as a professional conduct?
I have reviewed every publicly available board action over the last 3 years, all of them. I've read every word of every document that's available online.
So
And
when
so
you,
I do.
I apologize. So when you reviewed those affidavits, did you notice that for decades, for every rule violation that was specified, there was a second count for unprofessional conduct, and that this board has treated both in the affidavits and in its orders, that any violation of the rule is also considered an instance of unprofessional conduct.
I did not consciously acknowledge that as I was reading them.
I understand, and I think, as I understand it, this is what I'm asking, you're telling the board that you didn't feel like you did anything dishonest. You're not intending to violate the rules. You're not doing anything dishonorable. Is it that wording? Is that what you take issue with? Or please explain. I mean, just tell the board.
Sure. And first of all, thank you for allowing me the opportunity to speak. That is an accurate summary. And I think what I want the board to know is that when I think about the term unprofessional and dishonorable and unethical, I just want you all to know my intent and my heart, which is that in my heart, we want the same thing. We want patients to receive the highest quality care that they possibly can according to the standard of care, whether that's in person or online. And I never want to intentionally or willfully do anything to be out of compliance with the board's rules. The way that the clinic looks and runs today, I'm actually proud of, because I've worked on it really hard since before we got this notice, and even especially after. And just wanted to make sure that you could see that my desire is to do the right thing in your eyes as well as the patient's eyes, and not to come across as someone who's being rogue or trying to break the rules or trying to do the wrong thing, because that is not and has never been my intent at all. Whether that meets the, now I do understand regulations, and I do know that words mean things, and I do know that words have legally written definitions. Know that, I mean, but I just wanted you to kind of transparently see my intent.
And you described your military experience, and so you're very used to following regulations. You emphasize, or your attorney emphasized, that you're licensed in all 50 states. So, your practices before this investigation began, were they in compliance with the regulations of all 50 individual states?
That's an interesting question. And the reason why I'm licensed in all 50 states is because I've had a series of corporate jobs that usually required me to be the professional corporation owner or the owner of a national medical group that was licensed in all 50 states. And I actually currently have one of those positions as well, Chief Medical Officer of Open Loop Health. What I've learned is that if you ask 5 different attorneys to interpret 50 state regulations for you, you'll get 5 different answers. It is very challenging. However, every corporation that I have ever worked with has been under the impression, according to the legal counsel they have received, that they are operating compliantly. I've never worked for a company that didn't have internal or external legal counsel that was frequently advising them on the ever-changing 51 state licenses before, during, and after the pandemic.
So you were relying on the corporate attorneys. Were they an employer? Is that right? Or a parent company? What's the correct term?
One of the companies, yeah, that I.
So you relying on their attorneys to keep you abreast and to ensure that your practice was considered medical practice acts and regulations. Is that right?
Correct.
Obviously, they miss you.
I did.
You reside in Tennessee, is that right? What states are now, I mean, I know you do only telemedicine, but how many states do you really practice through telemedicine? Is it 5, 10, 35?
Hard question to answer.
Give me a rough number between 1 and 50.
At least 40.
And so again, I repeat my question now. Do you know whether right now your practice model complies with the regulations of each of those states for the practice of telemedicine?
As far as I know, yes, it does.
And I believe, it's my understanding perhaps you now retained your own attorney to advise you as opposed to relying on like an employer or parent companies. But you do understand, do you not, that none of those lawyers, nobody at those companies is licensed to practice medicine in Mississippi. You understand that? You understand that it is your medical license and no one else's that is placed at risk if you allow faulty or incorrect information. Understand that? And again, you've emphasized 50 state licensure. We have, from time to time, we've had licensees who seem to have a problem, complying with the regulations, the Practice Act of just this state. Do you understand that by taking on, when you accept licensure in 50 states, you are subjecting yourself to 50 different medical practice acts and 50 different sets of regulations? And that is an enormous additional obligation that you're taking on.
It is, yes.
Paul's last line of questioning brought up a question in my mind. If you are licensed in 50 states, how do you keep up with CME from all 50 states?
It is actually quite easy. There is an online site called NetCE, and I enter all 50 state licenses, and it has a repository of required and optional by state CME programs, and it's cross-referenced with how many other states will accept those courses. So, for example, the Mississippi has one required CME course, and it's opiates, but that also may meet the requirement for a few other states. So it's cross-referenced. So I do several hundred hours of CME a year to make sure that I'm compliant in all 50 states, but it's tracked in one location.
In that regard, in the last calendar year, approximately how many hours of CME have you taken?
At least 500.
And the attorney that you have now that consults with you on regulations in the states and therefore all states in which you are licensed to practice, how often do you consult with him on current regulations?
Prior to April 17th, it was about once a quarter, but on April 17th, I requested a more in-depth, more thoroughly detailed and analyzed, and I also asked him to bounce it off of someone else so that there can be two sets of eyes. And it's only been 30 days. I haven't received it back yet. I'm not sure going forward what the right cadence is, but my plan is to ask him to track regulation changes and notify me of regulation changes for all 50 states.
Do some states not require, excuse me, audio, video conferences with the patients?
The overwhelming majority do not require it.
But some do, and Mississippi is included. Were you, as of April the 17th, requiring video, audio conferences with your Mississippi patients?
Yes, that was a process that we were already rolling out as a part of our process improvement. But since April 17th, I have not conducted any visits at all. Mississippi.
And
Under any modality.
the standard operating procedures that you revised as of July 8, 2022, which is page 73 in the records, is that the procedure you were developing at the time this arose?
Yes, today's SOP looks very different from that and has undergone several series of revisions since then.
So are you constantly revising that standard operating procedure?
I made a revision to it this morning before I came here. It is a living document that is constantly evolving, which I actually said in the email from last July. It was a living document that was constantly evolving and still is such.
You mentioned Open Loop. Is that your company you operate under now?
I'm the chief medical officer there, so I don't practice there. I have an executive and administrative position there.
Do you have any other executive administrative positions?
I do. I mean, I have some freelance consulting and fractional director or advisor jobs for smaller telehealth companies who cannot afford full-time executives.
How many employees do you have?
Me personally is 13.
And what are they?
I have one full-time 40-hour-a-week nurse practitioner, and all of the employees are new since this complaint was filed. So I have one full-time executive assistant and a part-time executive assistant who does the scheduling for the patient video visits. I have a director of nursing who is an RN. I have a nurse practitioner, and I have another one on board this week. I have 4 RN BSNs, 2 LPNs, and 2 MAs, one of whom is a prior authorization specialist that helps me with that. And then, of course, we have the non-medical staff, the person who maintains the website, the people who do marketing. There's quite a team.
Do you have plans for any other positions?
I do. I have selected a 35 state licensed physician who is planning to onboard within the next 60 days to serve as a medical director under me and provide oversight to the other clinicians as well as to see and treat patients.
Do you have a plan or a procedure for continuing education of your employees?
Yes, first of all, they have a stipend. So physicians and nurse practitioners have a $5,000 and $3,000 a year CME stipend. RNs and below have $1,000, and it's all reimbursement based. They're not given to it up front. They have to do it and then they get reimbursed. And all of my current staff, actually, after I received the affidavit on April 17th, I had them enroll in a continuing education program. And I required them all to undergo medical ethics, medical documentation, and one more just kind of general best practices, a sort of professionalism CME course. And I tasked my chief operating officer to find some sort of nursing level weight management, because we have a lot of patients requesting weight management, CME as well.
In the last year, have you taken any medical ethics courses yourself?
Yes.
What have you taken?
I took a medical ethics and professionalism course online through the CME company I mentioned earlier. I've enrolled and in process but not completed a medical professionalism online course. And I actually attempted to preemptively enroll in and take the recommended course in the consent order, but I needed to have a name and phone number and address of someone recommending me to take it. So I couldn't sign up to that in advance.
There are a lot of other questions I could ask, but you have better questions than I do. Board, and she's willing to stay here and answer any questions you may have, discuss any concerns you have or anything else. I will also say she is willing to provide you with any medical records of any Mississippi patients you wish at any time.
Doctor, I'm David McClendon, internal medicine, Ocean Springs. I thought I had a lot on my plate. You put a lot on your shoulders. And certainly the reason you're here is because technology is advancing faster than we can appreciate. And even our rules are changing because of that. And I'm sure you're aware, you seem to be very well read with the whole process of everything going on, but that having 50 licenses, if you have an action against one license, that then there's a reciprocal action in almost every other state.
Yes.
So any other questions from anybody? Dr. Gersh had his hand up first.
I understand you've been reading ethics or listening to ethic talks. When you were doing this, did you hear the term clinical gaze?
I have not heard that term yet.
That's a big one, AMA stuff. What that is when you start seeing people as a problem list rather than an individual. So as a long-term doctor, that's a concern to me as we run towards all of this computerization and set up all these institutions that push clinical gaze. When you, in all your corporate jobs, let's say you were prescribing Ozempic, did you get payment from the company for using that drug?
If I may, I would encourage you to read the messaging between me and the patient. I'm sorry. I would encourage you to read the messaging between me and the patient. I think it paints a clear picture of the fact that my intent is not to rush, and my intent is to see them as people and communicate with them as people. I reviewed that again myself this morning, and I feel like it very clearly portrays my perception of them as people and not just diagnoses.
I don't have a question. I just want to say thank you for your military service to our country. We really appreciate it.
Dr. Lippincott.
Good morning, Dr. Purdy. What is the company that do you own the company that you're working for?
No.
What's the name of the company?
Do you mean the chief medical officer position, Open Loop?
The one with the push EHR.
So that would just be Dr. Laura Purdy, MD.
So do you own the push EHR?
No.
Where did you get that?
During the pandemic, I had a baby and I had thrush and I needed to be treated. And I went online and I looked for someone to treat me. And that is where I found was Push. And they treated me. And it was such a good experience. I actually wrote into the company and said, that was incredible. I really loved that. Are you hiring providers? Because I would love to work with you. And it's an open EHR, so all of you could have virtual practices if you wanted. You just have to buy into the malpractice policy for $60 a month. And so I signed up because I, as a patient, had such a good experience, and I wanted to be able to offer that to my patients as well.
So are you self-employed?
Yes.
You're with your practice, Laura Purdy, MD?
Yes.
And that practice is incorporated?
I have a professional corporation based out of Tennessee and 8 other professional corporations throughout the country. We're
And,
working on creating a 50-state network of professional corporations. It just takes time.
and since April, you've hired 13 employees?
Oh, no, since the complaint came in.
And when was that?
July last year.
So you've hired 13 employees since then. How many employees did you have before you got the complaint?
So in a variety of capacities, I want to say less than 5.
So the patient whose Mississippi physician filed the complaint, she contacted, how did she come to know about you think?
She signed up for Push Health.
How did she learn about Push Health?
I don't know. I would
Is
have to ask the patient that.
But you said you had a marketing person now. I mean,
So the marketing person runs my website and my personal social media. I don't do Push Health's marketing.
so you have a website promoting your practice?
I have a website promoting myself, and people can sign up to become a patient if they would like to.
And so she signed up to be a patient.
My website did not exist until about 3 weeks ago. So a year ago, how the patient came to Push Health, I don't know. That would have to be a question for the patient. But she came, so earlier in this discussion, I described the process of how Push Health randomly assigns patients to providers, and the provider can either choose to accept or reject. So this patient was randomly assigned. I don't know if it's random, but they have some sort of round robin where patients who come into the system by means which I do not know how they apply to the patient. The patients are assigned to a provider who's licensed in the state. And so I can accept or I can reject. And then when I accept the patient, I have access to the initial form that they filled out when they came into the Push Health system before they were assigned to a provider. And I actually underwent that process myself when I was a patient. So how I found the system is probably similar to how she found the system. I was Googling how to get a treatment for thrush online. So she probably was Googling how to get medication for obesity online, and she found Push Health and signed up.
And do you remember what her chief complaint was?
Off the top of my head, no.
So tell me, how did you do her history and physical?
So the way that it is done is they provide some of their history when they sign up. They're asked for medical questions. They also have the opportunity to put in vital signs, height and weight. And then when they, well, at that time, we have a different process now. But at that time, it was asking for questions, asking for ABC, asking for weight.
You were communicating with this individual, or was it on the questionnaire?
It's cute. So there's actually a page in there where you can see all of the communication between me and her, all of the questions that I asked her back and forth and all of the ways that she answered me. So it's both. So there is an intake form that they fill out when they sign up. And then there is additional two-way conversation between the patient and me.
And that's via text messaging.
Correct.
And did you have any audio or video contact with that patient?
The only audio contact I had with the patient was when she messaged me upset that her doctor had filed a complaint. And so I called her so that we could have a conversation about it because she was very upset that her doctor had done it. And that is documented in the record.
And when did you stop seeing Mississippi patients?
On the day that I got was April 17th
What year?
of this year, 2023.
So is that when you learned of the is that when you learned about the complaint?
No, I learned about the complaint. It was last year on sometime in July when Mr. Estes reached out to me and asked to receive the records of the 3 patients.
So you continued seeing Mississippi patients from Mr. Estes contacting you last July until April of this year?
Yes.
And did your clinical procedures change any during that time?
Drastically.
How?
So now when the patients come into the clinic, they receive an 8-question additional intake form that is submitted by one of my RNs or LPNs. They are required, and well, the first thing is we receive a copy of their photo ID. We have a copy of their driver's license and their insurance card, if applicable, on file, even though I don't bill insurance, but sometimes we need it for prior authorizations. We don't do anything until we receive a copy of their driver's license, and it's in the chart. After that, they get an intake form that is specific to the chief complaint, no matter what that complaint is. And then we require, if it is a weight management patient, so I'll refer to that because that's what these are. They are required to upload an A1C and labs within the last 12 months, or we will order it for them if they don't have it. They're also required to provide height, weight, and blood pressure.
What are the logistics of getting a lab in this telemedicine practice?
The logistics of receiving their paperwork or the logistics?
I mean, you send a request to a lab in Mississippi and they go get their blood drawn and then the lab sends the result to you, or what?
So it's an EHR integration with Quest. So if the patient will say needs an A1C, a CMP, and a triglycerides, I go into the ordering widget and I select them. And then so it depends on whether the patient requests it from their end. If they request it from their end, they pay the Quest fees up front. And then I have to approve their request. If I request it from my end, the patient is not charged. The order goes to the patient for approval. So the patient is never charged without their consent. And that's the case platform-wide, by the way. They're never charged without their consent and authorization. So when the patient approves, either requests or approves the lab, they enter their zip code because it's a Quest integration. And then they have a variety of local Quest labs to choose from. They select the lab and then they approve the order. And then a order authorization is emailed to them and is also available in their app by the push system. So they download it or they upload it and then they go to, well, they contact the Quest, they make an appointment, and then they go and have their blood drawn. Then usually within approximately 3 business days, usually, sometimes a little longer, depending on the lab or holidays, et cetera, then directly in the push system, I have a menu for new labs. So I open the lab, I can review the PDF of the Quest output. It looks just like any other Quest receipt. And then I release them to the patient with any recommendations and follow-up questions, basically with my response, whether it needs action or not. And they are stored and uploaded into the patient's file.
And how do you perform the physical exam?
So there's not a way to do a hands-on physical exam. And that's the case in any telemedicine visit. You can't do a hands-on physical exam. But now that we are doing video visits in Mississippi, I mean, the physical exam is what you can see. The other thing that we do is we ask them to upload medical records in addition to at the time of the A1C upload. So we have access to and can see what their most recent physical exam was, which is not a perfect substitute for doing it myself, but it does allow me to know that they have been examined by someone and nothing significant was found or was, depending on the patient.
If I'm not mistaken, I believe that our regulations require that the telemedicine procedure obtains the same information as that would be available in person. Is that not correct? Yeah. So are you aware that, you know, our regulations require that, you know, same information as will be required in a real life encounter is required.
Is it acceptable for me to ask a question in return?
Well, I'm the one asking the questions right now. But what would be your question?
My question would be, does it mean literally that the board would like for people who are doing telemedicine to somehow listen to the heart and listen to the lungs and press on the abdomen of the person on the other side of the camera? And if so, how do you envision that happening through technology?
That's a good question. Now, when you get a new patient like the lady who was asking for the Ozempic, how much time do you usually spend with them on an initial visit like that?
The video visits are usually between 20 and 30 minutes, depending on how many questions they have.
And how much do you charge for those visits?
They are free in states where it is mandatory. In states where it is optional, they are $75 per visit.
So these, like how do you follow these do you follow up with most of the patients who enter your practice?
I follow up with all of the patients.
How often do you see? Well, you don't see them, but you text with them, right?
It depends on the state. Now we do video visits, and the nurse practitioners who have onboarded are doing the same video visits. It's required every 30 days for the weight management patients. It's done on a monthly basis so that we can assess for side effects, assess for changes in new medications or medical history over the last 30 days, and then also do a dosage titration, follow their BMI, calculate total weight loss as well as interval weight loss, and adjust their dosage if needed.
Well, I don't have any more questions right now, Dr. Purdy, but I would like to join Dr. McClendon in thanking you for your service. And you certainly seem to be somewhat of a pioneer in the field of telemedicine.
I do refer to myself in that way, yes.
Thank you.
Thank you.
Dr. Woodward.
Team of, I do what you do in family medicine, except I do no telemedicine. So I'm really intrigued by what you're doing. Do you anticipate returning to the state of Mississippi, practicing telemedicine or something?
I would love to, because I know at the very least, I have 140 patients who are waiting for these specifically. Some of them even wrote letters to the board. I don't know if those were made available to you, but some of my patients actually wrote letters of support. And I even received messages in my app on the EHR as late as last night, wishing me good luck today. Because they are enjoying their experience, and in their opinion, they feel like they have a relationship with me and they don't want to lose it. But that being said, it is more important to me to be compliant with the board, and I've already identified a couple of physicians to hand them off to if I need to.
And thank you for your military service. After you finish your military career, you ever practice traditional clinical training as
Not office based, you know. I did hospitalist work.
Any other questions?
I don't have any more questions for Dr. Purdy, but I would like to make just a few brief closing comments after she steps in.
Mr. Chapman, you have any other questions?
No, ma'am, I'm trying to get up there. She's available, period. That's it.
Thank you. Yes.
First, just because Dr. Purdy mentioned on the stand, and Johnny can correct me, but the course that was recommended was the pro course by CPAP, because it can be tailored like to specific issues in a practitioner's practice. The board will be setting precedent here today. This board's decision. And this board has considered telemedicine, like I said, several times recently over the last few years, and just last year decided that Dr. Purdy's practice model was not good enough for this state. The board was well aware that there were other states that are more relaxed, that permit telemedicine to be practiced differently. But this board said, and I believe it goes to the clinical gaze issue mentioned by Dr. Thirst, was that there's already so much disconnect when patients and providers, that the board wanted to ensure, that didn't get broader. Now, Dr. Purdy, I was very earnest. I mean, obviously hardworking, and again, and I also thank her for her service. But before you go to practice in a state, and other about telemedicine, see, you need to know the rules and you need to know the laws before you start treating patients in that state. And that was, I think, the biggest, mistake that Dr. Purdy made. I hate to say that rules are rules, but, it just sounds pedantic. But if this board wants to change telemedicine, we have a process, a rules and regulations committee, and so that, trying to think of the right expression, but, amending them by fiat or by board decision, I think is not the procedure that is laid out and that this board traditionally follows. There was one statement in the SOP that particularly caught my attention. If you look at the definition of terms, patient requests telemedicine evaluation for the chief complaint of overweight/obesity. I have reviewed applicable state laws and ascertained that this request for the information provided is adequate to complete via virtual health. Obviously, Dr. Purdy had not, in fact, ascertained whether this state's laws and regulations permitted what she did, although she has made significant efforts to make sure that that doesn't happen in the future.
So again, I think Dr. Purdy was completely honest. I mean, she's been completely honest and truthful. But nonetheless, this will put a precedent. There are a lot of providers, I telemedicine, who don't do what I mean, she is licensed in the state, and definitely credit to her for that. But, other providers will be looking and think that, some level of discipline is appropriate. Rules were broken. She has admitted that. Fortunately, it's the board, and I made it, has to decide that. So I just wanted to remind the board that you looked at this issue very closely, and thank you.
We don't disagree. We know there will be something that you're gonna require of her from this. What we wanted to do was expose to you what she has done to come into compliance. And the issue here, to me, is, of course, she did not do what the law required. And Dr. Lippincott, you're right, there is a conundrum there. How do you have a physical examination by telehealth? But the fact of the matter is, telehealth is here and telemedicine is here. And I don't envy y'all in having to decide how to deal with it. What I am asking is, and I don't like the term punishment because that's not what I believe you're doing here, is let your decision fit what she has done and what she continues to do. This was not a willful wrong action. This is not a lot of things I have appeared before this board before going on. And it has been corrected and is in the process of being corrected more. What we would ask you to do is look at this doctor, see what she's striving to do, see how she's trying to comply and has complied, and take that into consideration when she makes decisions. She wants to be able to practice telemedicine in Mississippi, just as in the other states. And she will do anything you ask her to do to comply. And that's it.
I'll entertain a motion to go into to close this meeting to consider to go into executive session over this matter. Second. Any other further discussion on the motion? All in favor, say aye.
No.
Any opposed? Any abstentions? The motion carries.
Are we gonna take a lunch break?
I think I'd like to do lunch after. I don't think it's gonna take too long. Board is now out of executive session and back in a full meeting. Dr. Lippincott, the Secretary of the Board, will read the findings of the executive session.
The board finds Dr. Purdy guilty of violation of rules and guilty of counts 1 and 2. And the board is suspending her license for 3 months with the suspension to be stayed. The board is requiring completion of the CPEP probe course as discussed. And Dr. Purdy is prohibited from practicing telemedicine until June 17th to reflect her self-imposed abstention from practicing since April. And she is to report back to the board for review of her current telemedicine practice standard operating procedures in 3 months. And she can report to the executive director at that time. And we had, anyway, that's we'd like to thank you again for your service, Dr. Purdy, and that's all.
Any further questions could be directed to Dr. Clusen.
No, I'll work with him. We'll get this done.
Thank you. We'll now break for lunch for 45 minutes.
Thank you. Appreciate it.
items with the.
Well, Randy put on his best preaching.
Paul, are you ready to start?
Yes, sir.
You're back in full meeting?
Far as items 19 and 20, both need to be handled as executive
Put your mic up.
Sorry, I'll be a low talker. Items 19 and 20, both will need to be handled in executive session. I believe that it would probably be most efficient for us to do that as we have recently to do two motions to enter the executive session, one for each of those items. And then item 21 will also be an executive session, but that is going to be a full hearing with any witnesses. So I would suggest that we come back out here, return to executive session, and then clear this room. Of everyone except the board and witnesses. Does that make sense?
Can we do one motion for 20 and 21?
I think that
We can do it in one setting, but we need two motions.
I think 21
At the
because
same
of the
time.
full hearing that concerns the phones.
We can just stay back there instead of coming back out here. and doing it again.
Okay.
And 21 will need to be out here because.
I'll
Yeah.
I'll entertain a motion to go into consider to close the session. There's a motion. Is there a second? All in favor, say aye. Any opposed? Motion carries. Okay. We are now out of the executive session and back in a full meeting. Dr. Lippincott will read the results of the executive session.
The board voted to approve the investigative subpoena for case number 2023-071 and for the investigative subpoena for case number 2023-076 and the investigative subpoena for case number 2023-030. And as well, the board approved the examining committee report pursuant to Mississippi Code 73-2551. That's all.
Thank you. Paul?
Yes, sir. That included the next matter. This is also under the disabled and impaired physicians law. It will need to be held in executive session. It will be a full hearing. I anticipate that I've got two experts. I believe that Mr. Mercier, who represents the physician, also has two experts. And so I would request that you could close the meeting, go into executive session, and clear everyone from this room except for these experts. I think they're entitled to.
Yes, also, though, I believe Dr. Berry's father is here. I would request he be allowed to remain.
I have no objection. So we need to close the meeting.
Entertain a motion to consider to close the meeting to go into the executive session.
So moved.
Is there a second?
Second.
All in favor, say aye. Any opposed? Motion carries.
How long it lasts.
We now need a motion to officially enter into executive session on this matter.
So moved.
Motion and a second. All in favor, say aye. Any opposed? Motion carries. We are now in executive session.
conflict, exactly. The, this began as an action by the Wisconsin board, required, Dr. Delgadillo, licensed in both states, is required to, do an analysis, PMP report in Wisconsin, submit a, this board essentially mirrored, the requirement. The language is slightly different. As I understand the documentation, and we're gonna have to agree on the exhibits because there were some PMP reports in the documentation. We've saying we can't actually put the PMP reports, in the record. But we got 4 reports with self-analysis, and we got 4 essentially blank. And it's just was position of the executive director that didn't feel that the spirit of the order had been complied with. And Dr. Delgadillo, it is unspoken, but clear that it was intended that Dr. Delgadillo be practicing medicine, be providing the meaningful core report that is prescribing habit. The one thing I would say is that there is an email that where Dr. Delgadillo notified our compliance officer that he was not currently practicing in Wisconsin, because if he did, he'd have to comply with the full 2-year term of that order. So that raised some concerns about exactly what Dr. Delgadillo, was he making sufficient efforts to comply with the order providing meaningful supports. So I mean, that is the heart of the procedure.
Counselor, if you're ready to proceed.
That's what I don't know how to informally call Dr. Delgadillo. If you could stand, please.
If you would stand and raise your right hand and be sworn in. Before you publish these, what are these?
Yes, I was
Thank
going
you.
to. These are documents that have been produced to us by the board, by Ms. Martin. And it contains primarily the communications to date between the board and Dr. Delgadillo. So we are including in the copy we have reporting the PMP report and self-analysis. That being said, Mr. Barnes and I have agreed that due to the confidential nature of the information in the PMP report, that we are not going to introduce those or put those on the record. So you, however, have the full, yes.
We're going to take a 5-minute break, and we can get these exhibits taken care of. One of the doctors. Be right back. Thank you.
Okay.
Y'all 5 minutes normally turns into like 10 minutes, but yeah, I believe that.
We kind of linger and chit chat for about 8.5 to 10 minutes.
So I never want to say 10 because then it goes to 20.
That's right.
Yeah, back. Let us be counselor, thank you.
Thank you all. Dr. Delgadillo, would you please state your full name for the record?
James Lawrence Delgadillo, DO,
Where do you live?
in Corinth, Mississippi,
How long have you lived there?
since April 2018.
You have some documents in front of you, but you please turn to page 101. I would like to ask that what Mr. Barnes has previously handed you be entered into the records with May. And again, to note that these were the documents that were produced by the board to us, the full copies of which you either got before you as well as before Mr. Barnes and Dr. Delgadillo. So page 101.
Any objections to that?
No. We simply remove the PNP.
Thank
Okay, so looking at page 101, what is that document?
This represents the Mississippi State Board of Medical Licensure consent order.
Right, and it was entered in 2021. You turn to page 104. I believe the date is there. What is that date?
It is 2021.
May 12th.
May 12th.
Okay. And then specifically looking at page 102, you see there's a line that says the license was restricted, subject to some terms and conditions, and then we have a numbered list of those requirements. And there are 5 requirements in total. Is that correct?
That is correct.
I want to confirm whether you complied with each of these requirements. So if you would bear with me as I read through them, and we address each one. First, licensee shall provide the board with a written explanation as to why he failed to correctly answer the affidavit question related to his original application for permanent licensure and his subsequent renewal application. Did you provide that documentation?
Yes.
Please turn to page 106 through 108. Is that the documentation you provided?
Yeah.
And second requirement, licensee shall obtain his subscriber activity report via the Mississippi prescription each quarter. Licensee shall analyze said report and provide the board compliance director the analysis in a written statement. Dr. Delgadillo, did you do this each quarter?
Yes, I did.
You provided a statement and an analysis of your quarterly PMC report, correct? The first report you submitted, did that cover the quarter of April, May, and June 2021?
Yes.
I'm going to come back to that and let's go on for now. The next requirement is that licensee's practice of medicine shall be subject to periodic surveillance by the Mississippi State Board of Medical Licensure to monitor compliance with this consent order. As far as you know, was there ever any patient chart review done by the board?
No.
Did you ever object to that being done if it were asked?
No.
Were you at all times when you were practicing amenable to a review taking place?
Yes.
Okay. The next requirement, licensee expressly agrees he will not seek an appearance before the board for removal of part or all of the aforementioned restrictions prior to the completion of 8 quarterly reviews after the date of this ordinance. There should be no petition for reconsideration until after licensee has the restrictions from Wisconsin aforementioned stipulation order lifted, or upon the completion of 8 quarterly reviews, whichever comes first. This requirement gave you an option, true?
That is correct.
You would not petition for reinstatement until either you submitted 8 quarterly reports or Wisconsin, the order in Wisconsin, correct?
Yes.
Did you submit the 8 quarterly reports before you asked to appear before the board today?
Yes.
And is that why you are here today, asking for the restrictions to be lifted?
Yes.
We'll come back to the Wisconsin order, but to the final requirements, licensee shall reimburse first the board for all costs incurred in relation to pending matters. Did you reimburse the board for all costs?
Yes.
If you please return to page 112 and then look at 113. Is this evidence of your payment of the cost?
Yes.
So you have done everything required of you in this consent order, correct?
Correct.
Now let's run through the 8 reports that you submitted. So turning to page 3. Is this the covered email for your first quarterly report?
Yes,
And pages 4 to 19, which is not in the record, but is before each member of the board, yourself and Mr. Barnes, is that the PMP report for the first quarter?
yes,
And you actually resubmitted that PMP, didn't you? Because you weren't sure if it was in receipt.
that's correct.
That resubmission, is that on page 20 to 35?
Yes, it is.
And let's look at page 36. Is that your self-analysis of the first report?
Yes,
And when was this submitted?
July 1st, 2021.
And Dr. Valdivia, I wanted to note a couple of things here. In the first paragraph, you indicate that you're submitting those pages in order to satisfy the requirement in the consent order, right?
Yes,
The last paragraph, you say, if there are any questions, please contact me. Did anyone ever contact you with any questions or concerns?
No.
Now let's turn to page 37. Is that email for your second quarterly report?
yes,
And is it dated October 1, 2021?
yes, it is.
And pages 38 through 48 are the PMP for that quarter. Again, not in the record. Is
Yes,
that correct? Your self-analysis is on page 50.
yes,
And looking at that self-analysis in the first paragraph, you again indicate that you're submitting these pages in order to satisfy the requirement of consent, right?
correct.
The last paragraph again says, if there are any questions, please contact me. Did anyone ever contact you?
No,
Look at page 54. Is this the email for your third report that you made on January 3rd, 2022?
yes,
Okay, and the PMP, that pages 58 through 59,
yes,
56 through 58, and then your self-analysis is on page 59, correct?
yes, that's correct.
Now, in that self-analysis, you included an explanation of the PMP being only 3 pages long. What was that explanation?
I was released from my employment
Why were you?
and having a restricted license, Blue Cross Blue Shield of Mississippi would not credential me further. Therefore, me not being able to be credentialed through Blue Cross Blue Shield, my employer could not justify my practice there.
Okay, and in that letter, the self-analysis report on the bottom of page 59 and then page 60, did you provide a detailed explanation of the situation to the board?
Yes, I did.
And did you say that you were actively seeking other employment?
Yes,
And was that true?
yes,
Did you again ask the board to contact you if they had any questions?
yes,
Did they contact you?
no,
Now, Dr. Delio, I'm not going to go through each one of the next 5 reports individually, but did you submit all other reports as required?
yes,
Okay, so briefly, looking at page 62, dated April 1, 2022, page 63, the next PMP report, which is blank.
yes,
This was because you were still unemployed, correct?
that is correct.
Page 65, July 1st, 2022, is that your next report?
Yes,
Page 68, October 1st, 2022,
yes,
that's the next submission of your report.
yes, it is.
Page 71, January 6th, 2023,
Yes,
and then page 74, dated April 3rd, 2023,
yes,
and was that your 8th report?
that was my 8th report.
After your January 2022 report, when you first reported that you lost the job, did you explain why your PMP was blank with each subsequent report that you sent into the board?
Yes,
Did you provide updates every quarter on your efforts to obtain employment?
yes,
Were you continually trying to find a job during the time period of this consent order?
yes, I was.
Okay, please look at page 114. I think it's the last page. Is that an accurate listing of your efforts to find employment?
Yes, it is.
Has anyone offered you a job?
No,
Did you turn down any offers of employment during this time?
no,
Now let's briefly address the Wisconsin order that Mr. Particularly the communication regarding that. That's on page 77. Is this email correspondence between you and Kristen Wallace, representative of the board?
Yes,
Is it your understanding that the requirements of the Wisconsin order cannot be satisfied unless you return to work in that state in Wisconsin?
that is correct.
When did you move?
April 2018.
Okay, and what's the date of the Wisconsin order? Is that September of 2020?
That is correct.
Okay, so this order was not in place until after you moved into Mississippi, correct?
Yes,
So you did not know of any investigation by any Wisconsin board when you left to come practice in Mississippi, is that right?
that is correct.
You never, did you ever intend to return to Wisconsin practice?
No,
You did not leave Wisconsin because of restrictions imposed on your life, correct?
that is correct.
Last question. Did anyone at the board ever tell you that there were issues with any of your reports? Did anyone ever contact you after you reported being unemployed and tell you that your report while you were unemployed wouldn't count towards the completion of your consent order? Did anyone ever contact you to ask any questions at all, any feedback on your quarterly report?
No,
Did you have any intent to not comply with any requirement in your?
no,
There has been a comment made that somehow you made a belief that you may have failed to comply with the spirit of the order. Did you intend not to comply with the spirit of the order?
no.
Not to comply with the order, all of its requirements?
I plan to comply with requirements.
Do you want to stay in this?
Yes,
Do you want to return to the practice of medicine?
yes.
Dr. Belvedere is now available for any questions and you have with what?
Maybe that they're gonna, sorry. Let's look back at page, I believe, 101 is where we want to know the thoughts. And let's look at page 101. Paragraph 2 on page 102 says licensee shall obtain a prescriber activity report via the Mississippi Prescription Monitoring Program each quarter. Licensee shall analyze said report and provide the board's compliance director the analysis in a written statement. Licensee shall provide said statement no later than 15 business days at the conclusion of each quarter. First quarter due should include April, May, and June 2021. I read that correct.
Yes,
Look at paragraph 4. Licensee expressly agrees he will not seek an appearance before the board for removal of part or all of the aforementioned restrictions prior to the completion of quarterly reviews after the date of this order. Looking at the reports that your counsel mentioned brought to the attention of the board. After the first 4 reports, what analysis did you do other than to say, I'm not practicing, I don't have a job?
I was actively stating that, like you said, I was currently unemployed. I could not make an analysis on patients because I was not seeing any patients. But I was updating that I was actively seeking employment so that I may continue.
Did you not understand the order to be taking into account the presumption that you'll be practicing medicine when you provided a quarterly analysis of your prescribing habits?
I understand that, but as statement 4 also stated, I could not request that any changes be made to this consent.
You did not request that this appear before this board.
That is correct.
But did you ever ask Ms. Wallace? Did you ever call her and just say, I need to work something out with you because I'm not employed and I can't comply with the terms of the order? Did you ever have any contact like that?
Not contact like that.
And so just for example, if you look at page 63, there's an example of the PMP report for Dr. Delgadillo for January through March 2022. Flip over a couple of pages, page 66, the same thing. And let's look at the very back
page, Dr. page 114, Dr. Delgadillo. I believe, this was provided by the council, as evidence of the attempts to obtain employment.
Yes.
Dr. Delgadillo, I certainly, everyone here understands the importance of not being credentialed by an insurance company and provider. Blue Cross, but Blue Cross is, I mean, being paid by Blue Cross, that's not the only way to practice medicine in Mississippi, is it?
No,
What are the alternatives?
accepting other positions that may not depend on Blue Cross Blue Shield.
Yes. Opening your own practice.
Any redirect?
Yeah. Did you ever try to open your own practice?
I'll be honest, I did consider it, but I had spoken with other colleagues of mine who have been running their practice, and they said that for them to survive, they were heavily dependent on Blue Cross Blue Shield. They did not think the practice could proceed further if they were not credentialed by Blue Cross Blue Shield.
And is it your understanding that Blue Cross Blue Shield?
Speak into the microphone.
I'm so sorry. Is it accurate to, is it your understanding that Blue Cross Blue Shield of Mississippi covers about 80% of the commercial payers in Mississippi?
Yes.
And then just briefly returning to page 77, your email regarding the responsive letter. Do you intend to imply that you were specifically not returning to Wisconsin because of the order that is in place there?
No.
Do you have any plans to return to Wisconsin?
No.
Have you ever considered returning to Wisconsin?
No.
Nothing further.
Any questions from the board?
Hi, Dr. Delgadillo. So you currently have a license in Wisconsin and Mississippi?
That is correct, sir.
Do you have a license in other states?
No, sir.
Could you remind us what was the action against you in Wisconsin for?
Originally, I had prescribed too many narcotics at that time. And therefore, that's why the order, which is very similar to the order Board of Mississippi had provided, was initiated. But that was only if I returned back to Wisconsin and practice.
So the Mississippi consent order, that was more or less a mirror image of the one they did in Wisconsin.
Yes, sir.
You know, your consent order, does it state that if you get your license straight in Wisconsin, the restrictions in Mississippi will be removed?
Yes, that is what the consent order Mississippi had stated.
Okay. I guess I'm not sure if it's pertinent, but what was the reason you left Wisconsin and decided and didn't want to go back?
To be perfectly honest, in 2014, I got married, but my wife lived in Corinth, Mississippi. I still had my job in Wisconsin. But when I left in 2018, I felt it was a good time to come to Mississippi and start fresh. Be with my wife.
Thank you. Thank you. I don't have any other questions.
Any other questions? Okay, any other questions?
I just wanted to say for the record that if you board was going to look at it, the original affidavit for Mississippi is starts on page 95. 5 pages.
Doctor, you may be excused. You have any other witnesses? At this time?
No witnesses. I'll wait. Closing statement.
Okay.
We need to go into executive session, please. Is there a motion?
I move we
Motion closed.
close down this one to go into.
Is there a second? All in favor, say aye.
Aye.
Any opposed? The motion carries.
Yes.
We're back in a full meeting. Dr. Lippincott will read the results of the executive session.
The decision of the board is to approve Dr. Delgadillo's request for removal of the consent order.
Congratulations.
And informally to remain in contact with the executive director.
Yes. I'll discuss that with.
All right, moving on to July board meeting dates. There's a note here. It says the July 19th and 20th board meeting dates in conflict with the Bar Association conference. My take on it is that the Bar Association conference is in conflict with our dates.
Yeah, but if we want her,
They're, you are good. You're excused.
Oh, yes. It would be hard. I'm attending the conference and several attorneys from our office.
Yeah.
So it's gonna be really hard.
It's a pretty big
Hearing
deal.
officers.
it's
Yeah.
a pretty big conference, I hear.
It's very important.
So
We're,
no.
No, it's that.
We still things. So are we gonna do July 12th, 13th, or 26th and 27th of July?
You won't tell me. I'm available either one of those.
I'm gonna be out the last week.
Say the date again, please.
12th and 13th.
Either the 12th and 13th of July or the 26th and 27th.
13th of what?
July. I can't do the 26th and 27th. Well, I'll be out of town.
I'm available either day.
We're leaning towards 12th and 13th.
July 12th.
Okay, so we're deciding to move to the 12th and 13th. 12th and 13th. July. We now have elections for our next round of officers.
Can I interrupt?
Yeah.
I think the board will agree with me that your leadership through the last 2 years has been exemplary. It has been very sincere and thoughtful. You have served the people of Mississippi well, and you have served this board well. We're proud of you and we thank you.
Thank you, Tom.
Great.
Yeah, this has been the greatest professional honor I can't, and I pinch myself that I'm sitting here as president of the medical licensure board. And so the honor of serving with all of you, staff, amazing physicians who also, have found their way here. This is one of the most special experiences I think that we could all have. And it's been a great, great honor for me. And so that's my last duty. I'll try to help lead the next round. In terms of, guess we'll start at the top and work our way down for the president office. Certainly open to nominations, but I would like to nominate Dr. Michelle Owens for the incoming president. Any other nominations for that position?
I don't think there will be.
I'll entertain a vote. All in favor, say aye. Any opposed? Motion carries. For the vice president position, I'd like to entertain a nomination for Dr. Ken Lippincott.
I will nominate Dr. Ken Lippincott.
Very good. All in favor, say aye.
Aye.
Any opposed? Motion carries. It's just kind of wonky that we're doing it this way. But and then for the incoming secretary position, I'd like to entertain a nomination for Dr. Tom Joyner.
I nominate Dr. Joyner.
Any other nomination?
Reciprocity. Love it.
All in favor, say aye. Any opposed? Motion carries. Congratulations, everybody.
Teach Michelle to show up.
Yeah,
Mm.
right.
Uh-huh.
All right, we're adjourned.
Thank you.
Thanks, David.
Thank y'all.
So much.